Good morning. Today is Thursday, March 19th, 2026, and welcome to today's regular meeting of the California Fair Political Practices Commission. Ms. Vo, will you please take roll?
Commissioner Brandt?
Here.
Commissioner Ortiz?
Here.
Commissioner Wilson?
Here.
Chair Silver?
Here. Excellent. Let's move on to item number 1, and that's going to be public comment for items not on today's agenda. Do we have any public comment for item? Okay, excellent. I assume they are not in the room. Do we have any public comment in the room? Okay, well, let's start with the public comment that is not in the room. Go ahead.
Good morning, Chairman Silver and Commissioners. My name is Christopher Butner, a Calaveras County resident. Prior to my addressing a consequential matter appearing in the executive staff reports of the FPPC's August 21, 2025 hearing concerning case number 2025-00042, I wish to acknowledge the Enforcement Division for diligence in investigating violations of the Political Reform Act. Political Reform Act violations run rampant in Calaveras County, evidenced by my individually filed complaints against 4 of the 5 county district supervisors, converting to 4 commission-initiated complaints and cases. The timeliness of the vital work performed by the Enforcement Division is negatively impacted by the state's inadequate budgetary support for the FPPC. Logic dictates the corollary of increasing the FPPC Enforcement Division budget would be a significant boost in enforcement stipulations collected, translating to increased revenue. I am submitting letters of support on behalf of the FPPC to the State Assembly Budget Subcommittee 5 on State Administration and the Senate Subcommittee 4 on State Administration and General Government, both now engaging in legislative budget hearings. I respectfully address this commission specific to an open and pending case initiated by one of my complaints, urging the FPPC's expedited conclusion and case determination in the interest of minimizing harm to the community in the matter of the campaign non-filer investigation of Stopper for Supervisor District 5 2018 and Benjamin Stopper case number 2025-00042, and in consideration of 12 probable cause findings on July 21, 2025 of Supervisor Stopper's presumed violations of the Political Reform Act. District 5 Supervisor Stopper filed his intention on March 6th with the Calaveras Elections Office, seeking re-election on June 2nd for a 3rd consecutive term. I assert Supervisor Stopper has harmed the public's right to be informed about
Butner,
his potential.
I apologize for interrupting you there. Just to avoid potentially prejudicing the commissioners as to this open case, I'd recommend that if you have any additional information that you wish for the Enforcement Division or the FPPC to consider, that you reach out to the Enforcement Division. If you don't have their contact information, I believe they have yours and they can follow up with you. As to your first comment, we greatly appreciate you highlighting the fact that we can always use greater resources. We do have the entire state as our jurisdiction. So we greatly appreciate you reaching out to the legislature and advocating on our behalf. You can go ahead.
The outcome of the District 5 supervisor election on June 2nd, 2026 will be compromised should Supervisor Stopper win re-election while his FPPC case lingers, depriving voters the opportunity of an informed choice between recalcitrant District 5 Supervisor Stopper and his challengers. Sufficient cause appears to exist for the Enforcement Division to levy substantial fines upon District 5 Supervisor Stopper and to bar him from continuing to hold public office. My name is Christopher Butner. Thank you very much. Good morning, Commissioners.
Thank you, Mr. Butner. Do we have additional public comment? No. Okay. Why don't we move on to item number 2, approval of the January 2026 meeting minutes. Do we have any suggested edits, comments from commissioners?
Motion to approve.
Before we do that, let's just see if we have any public comment on the minutes. Hearing and seeing none, we have a motion to approve. I'll second.
The January 2026 commission meeting.
Excellent. I'll second that, Ms. Vo.
Commissioner Brandt?
Aye.
Commissioner Ortiz?
Aye.
Commissioner Wilson?
Aye.
Chair Silver?
Aye.
Motion passes.
Excellent. Thank you. Okay, let's move on to our consent calendar. Today, that's going to be items 3 through 9. We have one item that relates to legal division. We have several items, the rest of those items that relate to enforcement. Before we have our Enforcement Division Chief come up to the table here, is there any discussion as to item number 3, so that we can get that out of the way first? That would be our regulation projects for 2026? Okay, okay, go ahead, Commissioner
Okay,
Ortiz.
thank you. New, combined campaign statements and reports. Could you explain to me how that happens?
Sure. A lot of public officials have multiple positions for which they're required to file SEI statements. So we have a regulation that exists to make it as efficient as possible for them in filing, but to ensure that everything gets disclosed that needs to, because certain positions have certain filing requirements, some greater than others. If someone is on 5 different boards, which can be the case, especially at the local level, rather than having them file the same statement in 5 different places, we have a process by which they can file a single statement and then provide copies to the other jurisdictions. The regulation's there to ensure, while allowing that process to ensure that adequate disclosure takes place at all the different locations where they're filing. So an issue came to light last year that we felt needed to be cleaned up. So we're going to clean up that issue regarding state legislators who are also in 87-300 code filing positions. In the meantime, we're going to take a look at that regulation, work with our SEI people, and see if there's anything else that needs to be
Sounds
cleared
good.
up.
Thank you.
Commissioner Wilson?
Kind of as a technical question, Council Bainbridge. This consolidation of filing the forms, is this something that was recently developed? Or was there a point where you might have an appointee at the local level who was filing multiple Form 700s?
It's been around as long as I can remember. It has changed with electronic filing, particularly electronic filing becoming mandatory for 87-200 filers. So that's part of what we're looking at to make sure we've just kind of got all the scenarios in place to make it efficient and get full disclosure.
Okay, thank you.
I'm glad Commissioner Ortiz brought this one up because to me, this is an incredibly important regulation. I met with folks all over Southern California and some in Northern California as well, who are filers, who are 87-200 filers, also 87-300 filers. And they're frustrated with aspects of the system of filing these combined statements, of having to file with different filing officers. And I feel like we can take that feedback, act on it, address some of the issues that General Counsel Bainbridge noted in terms of having to file multiple places where you're both 87-200 and 87-300 filer, and move forward in a way that provides transparency, but also doesn't create an unnecessary administrative burden on public officials.
Yeah, and I would obviously encourage any filing officials throughout the state that have seen issues with it to reach out to us, because they're the people at the front lines doing this, so it's helpful to get their input on when we're trying to make things easy for them.
And I don't know if we mentioned this at our Chico meeting, but Executive Director West, General Counsel Bainbridge, several other staff members actually engaged with quite a few folks up there in the North State about their interactions with the FPPC. And as I understand, it was largely positive, but there are, the reason why we do these meetings is to kind of identify potential blind spots and then act on it and propose regulations. So I'm glad that we took this approach. Any other regulations on here? Any other comments on the calendar? Okay. So I'm going to welcome our Enforcement Chief, Bone Break, up to the table. Good morning, Chief.
Good morning, Chair Silver, Commissioners. I am happy to answer any questions you may have about this consent calendar.
Sure. You've been very busy.
Yes, this is my largest binder by far.
Yeah, it looks like, so I looked at the stats. I had to break out my calculator. It looks like there's over $220,000 in fines levied. So we're close. It's March now, so this is basically reflecting Enforcement Division's work in January and February. And we're close to the total amount that we levied in 2023 and 2021. Don't feel like you have to confirm that. I didn't ask you to look at those numbers first. That's something I looked up. I think that's incredibly impressive. And I don't think really the fine amounts are the most important part of what this agenda and the January agenda really reflect in terms of enforcement. I think it's that we're focusing on violations that have the most serious public harm, right? You have conflicts of interest cases on this agenda. You have multiple misuse of public resources for a campaign purpose related cases on this agenda. On our last agenda, you had campaign money laundering. These are exactly the sorts of cases the commission directed you all to focus on, and you're being, absolutely successful in approaching that. So with that, do we have any of these items on the consent calendar, so 4 through 9, that commissioners would like to discuss? Commissioner Wilson.
Yes, thank you, Chair, and thank you, Chief. Item number 5, the matter of, I may not be pronouncing it, but it's Jeannie or Jenny Luttrell. All the facts were laid out in detail. This was a high-level deputy superintendent who this fine was levied against. She's no longer working in that position, but had extensive experience. And in the stipulation, there's the option of fining this particular individual up to $30,000, but she was fined $8,000. And I'm just curious why the maximum fine was not levied, given the fact that she had extensive experience and had filed her Form 700 in certain years, but not in other years. And then in terms of the profits that the business at issue made, it was anywhere from $10,000 to $100,000 in multiple years. So I was just I'm curious and was kind of perplexed why the fine was $8,000 instead of being closer to $30,000.
Absolutely. So when the Enforcement Division determines what fine to suggest on its stipulations, we look at all of the factors in the Regulation 18.361.5. Here you have one conflict of interest violation, as well as several non-reporting violations on this particular respondent's SEI. Here, the conflict of interest violation was charged at $4,000, which is almost maximum, which is in line with the comparables. And the reason for that is looking at the comparables, which is one of the factors in the regulation. The $4,000 is on par. There is no pattern here. The evidence suggests that this was negligent and not deliberate. This particular individual worked extensively with the Enforcement Division to correct anything she could come into compliance. And therefore, the $4,000 for the COI, the conflict of interest, we determined was appropriate. Additionally, the same factors were considered when we looked at the non-reporting on the SCI. Here, the evidence suggested that the respondent misunderstood her reporting obligations and misunderstood the fact that even if the business was not profitable, it was still an obligation on her Form 700. We believe that this was a negligent violation, that it was not a deliberate violation, and therefore, based on those things, as well as, again, the things that we consider, we believe that the most public harm was caused in the year that the conflict of interest violation occurred, and therefore we believed that even though comparables that we found only charged the $1,500 for the SCI violation, we believed that the public harm with regard to the SCI in the year that the conflict of interest occurred was higher public harm, because had that been reported, there was a possibility that that conflict would have been caught and avoided. However, the other years, we didn't see as high of public harm, given that the conflict of interest did not occur there, therefore being more on par with the comparable that we cited.
I follow and appreciate your analysis and the way you clearly outlined it as it relates to public harm. In terms of the profits that the business did or didn't make, is that something that was verified by enforcement, or is that something that Ms. Luttrell, a former deputy superintendent, outlined to the Enforcement Division?
I
mean, it's more of a, you don't have to give me exact, I'm just more just a general. Just a general response is fine, you don't have to.
I know for purposes of the stipulation, with any stipulation, we work with the respondents, and what we do is we use the information that we obtain as part of the investigation. And as part of the investigation, of course, not only do we investigate, But we also do usually interview the respondent. And so some of the information in there is information provided. There is no delineation in this particular stipulation as to whether this was investigated versus provided by the respondent.
If I vote in favor of this item, it'll be reluctantly, because I think the fine is too low. I follow and respect, the arguments that you outlined, but I also think it's important for us not to give an incentive to someone in the future to say, you know what, I made a few $100,000 on this deal. Not saying that was the case here. So, $8,000 fine is a small price to pay. So I just feel there's more public harm if if their business is generating a profit and they consider the fine as just a cost of doing business.
Understood, and we can take that into
Right,
consideration.
okay.
Thank you.
Commissioner Brandt?
Thank you. On the matter of Melanie Bagby,
Yes.
so the comment we got about, and the public comments we got about attacking the person who reported, I think it's important for our commission to be clear that we are supporting people who report, and we do an investigation and do those kinds of things. I want to note that the fine, the maximum is $10,000. It's a $9,000 fine. And there is nowhere in here where you considered, oh, well, this reporter this person who filed the report is, someone we shouldn't listen to. As the comments from the public comments that were submitted, you did not consider that. Is that right?
That is correct. We
Okay.
did not.
And so I think those kinds of comments, and I don't think that those are helpful to us, and I think that they get in the way, if anything. And this is for future people, if they would think that they're going to submit comments attacking the reporter, the person who filed the report, that's just not going to be helpful here. So I just want to be clear. And so thank you for that, and I appreciate it. I'm ready to vote on any of them.
I want to thank Commissioner Wilson and Commissioner Brandt for their comments on these steps. Quite a few steps on this agenda, so there's a lot of things to talk about. I think in terms of enforcement penalties, what's really important is that we provide enforcement guidance about how we want to handle specific types of violations. To me, conflicts of interest are some of the most serious violations. I'm interested in how we can use 1090 to increase potential violations, or I should say penalties for these types of violations, and perhaps seek legislation that could give staff more leverage in negotiating settlements related to a violation, specifically for 1090, where we can draw the funds back from a violator. So that's more of a Lindsay thing, I should say, a Ms. Nakano thing. But that I think is really important here. So with that, do we have any public comment on the consent calendar? No public comment on the consent calendar. I'm gonna give Commissioner Brandt a moment to come back. No, you're fine. I'm gonna move to. I'm going to move to approve the consent calendar, items 3 through 9. Commissioner Brandt?
Second.
Ms. Vell?
Commissioner Brandt,
Aye.
Commissioner Ortiz.
Yes.
Commissioner Wilson,
Aye.
Chair Silver,
Aye.
motion passes.
Okay. Why don't we move on to our next items here, and those, as Ms. Vo pointed out, are our default proceedings. Those are going to be items 10 through 13. I believe we have some questions here related to these, but is there any background information you think would be helpful for us to have before we jump into questions?
So one of the questions that the commission normally has is whether or not we have had any recent communication. No, we have not. As all of you know, we did notice these as pre-notice at our prior commission meetings. And since that time, and I have confirmed right before this meeting with both of the attorneys on this, we have not had any communication or contact from these individuals.
Any questions, comments from commissioners? One question that I had, I don't know if this is going to be the question that Commissioner Brandt had as well. I think we might have noted this. I think maybe Commissioner Wilson noted this at the January meeting. It looks like two of these folks are from the same agency.
That is correct,
Could you remind us of, our interaction with the agency, with the filing officer, what we've done to encourage these folks to engage with us rather than pay, these significant fines here?
Absolutely. So these particular positions were added to a conflict of interest code during the tenure of this employment. And therefore, when the person took employment, the position was not in their conflict of interest code. It was added later. And so when that occurs, the assuming office needs to be filed within a certain amount of time after it's added to the code. Here, the filing officer, who we have contacted, our understanding did reach out to these individuals on several occasions. We also reached out to these individuals on several occasions. And that was all the individuals who were added but didn't file. Here, we only have two going to default. One of them, as you can notice, did end up filing in the last year all of the statements of economic interest. And that is reflected in the default documents. That individual is still in office and did file. The other individual is no longer in office and did not file. And so we have made every attempt. My understanding, the filing officer also reached out, making attempts. But the actions of the individuals here do show that there was some notification, especially with the second, I think it is Jesse Long. This person did end up filing. So it is clear that those communications, at least in this case, were received.
Okay, and that's reflected, it seems, in the fine amount here?
Absolutely, yes.
Okay.
We compared that to defaults where the individual did file versus the other where the individual did not.
Excellent. Commissioner Ortiz.
Thank you. I have just a general question. Because these are substantial penalties. How do you process collecting the fines?
So the enforcement division does not collect the fines. That goes to, I believe, our administration department. I will defer to Executive Director West, who may be able to provide more information.
Hi, thank you. So what ends up happening is the enforcement division gives a couple more notifications and they get transferred to our administrative division, who then tries to collect on the debt. Included in that collection effort is going through the franchise tax board for tax intercept, so that if they get a return, then that is applied to the debt. We also put liens on any real property and renew those every 10 years. And then we just recently started a settlement process that after it's been in collections for many, many years, we can assess it and see if the interest can be waived or things like that. But we also do attribute interest to these debts as they accumulate years and years of being unpaid.
So when it is in a collection agency and you said some of them take years, then what happens? You give up? What do you do?
I don't personally give up, but no, what we do is renew the judgments every 10 years. So if they ever sell their property, then that lien is on their real property. And we have been exploring if we want to be more aggressive. We've tried collection agencies in the past and the Attorney General's office, and none of that has been successful because it's not a high priority workload for the Attorney General's office. So we're always exploring whether or not we want to be more aggressive in trying to collect these penalties, which obviously then takes staff time. So we always have to weigh it against how much staff time we can apply.
Okay, thank you.
Quit.
Commissioner Brand?
So I have one question for all three of them, and just confirming that there has been personal service at some point for all three of these. I mean, we talked about this before, but I just want to confirm that.
Yes. So
Okay.
if you look through the certification of the records, you will see all of the different times we have reached out, as well as the required service on
Yes.
each one of these.
Great.
Yes.
The next question is, do we know if any of these have language issues? In other words, they were served in English? Do we know if there's anything? I mean, I don't know. I'm just checking. And if we don't know, that's fine. And that's fine. I mean, then they haven't responded. And I noticed one is a former regional recreation director, one is still a recreation director, and he's the one who filed, or they're the one who filed.
Correct, yes.
And okay, so I don't understand this, how people just don't respond, and then we get these kinds of things, and then we spend a lot of time, I don't know.
I completely agree with you.
Right, yeah, no. Or at least the
I've-
$15,000 question, yeah.
I've asked our executive director if I could call these people.
Yeah.
And I've been told we have procedures for other people to do this.
Okay.
Which we absolutely do, but I agree with you. It's it's frustrating. It's a lot of different emotions. I feel genuinely, awful for these people. That they're going to be subject to a life-changing fine.
Right.
Right?
Right,
But the
because it
reality
goes on their
is-
record. Right.
It goes on their record. I mean, they like Ms. West said, if they sell their home, it can be levied through their salaries, right? But the reality is they chose to engage in the political process in the public sector.
Right, and well, I mean, I think recreation directors, that's less of the situation, but nevertheless, they had notice. We did everything we could to get them. No response, and I just don't know how we do anything different. But I just, that's why I just went through. Yes, I know we do this. I just want to clarify for the public record and the public who's here that we're doing everything we can to get to these people. So, but yeah.
And just so we're clear in terms of responsiveness, so it sounds like we did not hear back from Ms. Evans, from Ms. Innocent, from Ms. Sanchez. We did hear back from, or Mr. Sanchez, my apologies. We did hear back from Jesse Wang. They filed, however, they refused to
So
engage.
just because we're going to a default doesn't mean they never engaged.
Okay.
And so there are times, and you will see in the communication log, for example, the first default for Evans, Evans did engage at one point, however, not recently. And therefore, there was quite an extensive process before we got here during a time of not engaging. But I never want to say they never engaged.
Okay. Thank you for that clarification. Commissioner Wilson?
Also, I think it's important, as a follow-up to Commissioner Brandt's comment, which I think was directly on point. I know in prior FPPC meetings, even going back prior years, Executive Director West highlighted the fact that not only is every effort made to give the person the benefit of the doubt, but if someone, for example, is suffering from an illness and is not in a position to respond, that's taken into account. So I think it's important to clarify that the process is does not mirror like a collection agency where they're, harassing you. It's a very professional, deliberative process. So just wanted to comment on that as well.
Yes, and as I pointed out, I think the last meeting, we do have the pre-notice default, which is not required. But it's one more step that we take to try to get a hold of these people and to have these people engage.
Any other comments from commissioners? Do we have public comment on this item? Okay, so the respondent from item 5 called it. Why don't we take public comment on items 10 through 13 right now, and then I would like to seek guidance from General Counsel and Executive Director as to how we would handle public comment related to an item that we already approved. Okay, go ahead. Public comment. Go ahead.
Hello, I'm a resident of Adelanto. Can you hear me?
I can. Thank you. Thank you for calling us today. Go ahead.
Thank you. I'm calling as a resident anonymously because of the fact that Councilwoman Evans repeatedly attacks those who bring up the fact that she works under the table and does not claim funds, campaign or otherwise, from cannabis companies here in Adelanto that are licensed. There is AES, a solar company that in 2022 donated to her campaign. She recused herself from those council meeting agenda items, but there are other agenda items that she did not recuse herself from, concerning the fact that cannabis companies were giving her funds, and then she would turn around and
I apologize
vote
for
on her.
interrupting you. Just one moment. So I just want to make sure that the commission isn't prejudiced as to the circumstances in this particular matter. So if there's anything that falls out of this specific default proceeding today, I'd highly recommend that you go ahead and reach out to our enforcement division so we can investigate those allegations. But today we're considering what's in this specific default proceeding for approval. So we don't want to be in a situation where, just so you can kind of understand where we're coming from, we don't want to be in a situation where down the line this penalty is challenged in court for bias or prejudicial contacts. So that's why I stepped in. But go ahead.
Thank you for the clarification. So I would say that the fact that I read the 189 pages of the accusation against Councilwoman Evans, and to see that she just deliberately would not engage and take care of her responsibilities is amazing, and shows that she doesn't think that there will be any ramifications to her. It's been really hard to be a resident and witness these types of things happen in our city, and see that there really is no movement towards the justice of the people. Thank you so much for your time. I appreciate you, and I appreciate all of the hard work that everyone at the Fair Political Practices Commission does on behalf of the residents of California.
Well, thank you, and thank you for taking the time to speak with us today. We really appreciate it. So, do we have any additional public comment on items 10 through 13? Okay.
Do I move?
You
Yeah.
can.
I move to accept, support, whatever, all the 10 to 13 default proceedings, requesting the commission approval.
Okay, I second. Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Chair Silver,
Aye.
motion passes.
Since we have a public commenter who wants to discuss an item that's already been completed, how do you suggest we proceed, General Counsel Bainbridge?
The item has already been ruled upon by the commission. However, if the chair would like to take the comment, they still can.
Okay, I'm inclined to take the public comment unless there's objection from other commissioners.
No, not at all.
We will move on to item 14, but first I'd like to allow the respondent in item 5 to present the public comment.
Right, and just for a point of clarification or more inquiry, the item number 5, and I'm not suggesting this, but from a procedural standpoint, item we previously adopted could be reconsidered technically, but I'm not recommending that. Just wanted to clarify that we had to go back and redo a vote. We could do that in theory only.
Public comment? Go ahead.
Hello, I'm sorry. Oh, Good morning. My name is Janae Luttrell. Thank you for the opportunity to speak to the item number 5 today. Specifically, I'd like to speak to Commissioner Wilson and address some of the concerns that were raised in his comments. I am Janae Luttrell, the respondent in this matter. I'm addressing the Commission today to provide a critical correction to the factual record regarding the jurisdictional nature of my private business interest and the proactive steps taken to ensure legal compliance. During the previous discussion of this case, it was incorrectly represented that the profits for my business, Real Matters, Inc., occurred within my county of service. This is a significant factual error. Jurisdictional separation. My public service was strictly limited to San Mateo County as deputy superintendent. All business activities and resulting profits for Real Matters, Inc. occurred exclusively in San Diego County. There was no overlap, no local contracts, and no financial nexus between my Southern California business and my Northern California public duties. Most importantly, at the time I assumed my role in San Mateo County, I sought and received an agreement approved by San Mateo Legal Counsel. This agreement was specifically designed to ensure that no conflict of interest could arise, as neither I nor my company received any funds from my jurisdiction of service. While I've accepted responsibility for the reporting errors on my Form 700s, I asked the Commission to recognize that I acted in good faith by following legal guidance to isolate my private interests from public duties. This record should accurately reflect that there is no potential for personal financial gain from my official actions. Thank you so much.
Thank you, Ms. Luttrell. Executive Director West, General Counsel, can you speak to what our options are at this juncture? It sounds like, and please correct me if I'm wrong, Ms. Luttrell, that you're disputing the facts in the stipulation. Is that correct?
I'm not disputing the facts. I'm just clarifying the comments.
In the stipulation.
I did not receive any funds. Sorry.
No, go ahead, Ms. Luttrell.
I did not receive any funds from San Mateo County, either personally or through my business.
Okay, but you're not disputing the actual
all
violations that were set forth in the stipulation, that there were conflicts of interest that you failed to disclose.
Correct.
An economic interest, correct?
Correct.
Okay.
All right.
Correct.
As long as
I
she's
am
not
not
disputing the
disputing-
facts of the stipulation as she signed and agreed to, then this is a public comment that can just be accepted.
Okay. That's helpful.
I'm just clarifying. I just want to ensure that the comments reflected the accuracy.
And
situation.
that is your right, and I'm glad that you did follow up on that piece. You know, Commissioner Wilson makes a great point that there is potential for reconsideration. I'd like to better understand our options in terms of that. But first, Commissioner Wilson.
Thank you, Ms. Luttrell, for your comments. I did not make any reference to San Mateo County or distinguish one county versus another. My comments were general in nature. And if there's any issue regarding the facts in the stipulation, I found that the stipulation was very clear and outlined all the details, dates, and so forth. So thank you for your public comments.
Thank you for the opportunity. I just want to make sure that the public understands that the profits were not connected to my public duty. In fact, it happened in a completely different county.
Thank you. So I'm gonna withdraw my previous request to the General Counsel, and I'm gonna ask other commissioners: do we want to hear what our options are in terms of reconsideration here, or would we just like to move on to item number 14?
I'm not recommending reconsideration. I only brought the issue up for clarification on what the procedural options are. Right. I'm not suggesting that it be exercised because I think that the motion, at least from my standpoint, was pretty clear and definitive.
And Ms. Luttrell is not challenging the facts in the stipulation. That's
Correct.
What's critical. So there's no reason for us to reconsider because the facts in the stipulation. And so it's more for public awareness that there was no connection. There was not something that she was doing something in San Mateo County that would make money off of her public.
Agreed.
So,
I'm glad we're all on the same page. So then I'm going to recommend that we move on to item number 14. So thank you, Chief Bonebreak. And item number 14, that would be adoption of proposed amendments to Regulation 18361.4, probable cause proceedings. We're going to welcome up to the table Senior Commission Counsel, John Fazer. Good morning, Mr. Fazer. Sure. 1 moment, Mr. Fazer. No problem. So just so everything's on the record, Commissioner Brandt does need to step out for 15 minutes. I would like to have Commissioner Brandt here for the entirety of this item. So I'm going to suggest that we move on to item number 15, which is a launch of our new FPPC website. I know that's kind of a technical item. So if we're not ready to do that, we also have the option to move on to our executive staff reports. I think that's something that could be resolved within the time period. Yeah, agreed. To note for Commissioner Ortiz, she made a good point. We need to get a clock that tells the correct time more than twice a day. Uh-oh. Yeah, she never gives up. She never surrenders, Ms. West. Okay, so my recommendation is that we, how about this? Why don't we take a 15-minute break? Is that all right with everybody?
Okay.
Okay.
Whatever you say, Chair.
So I'm gonna move that that we go into recess.
Okay.
And we will be back at 11:15. Thank you. 11:15. Current time. Oh, my apologies. That's not 15 minutes. So that actually 11:05, not according to that clock. So 11:05, everybody. Thank you. us, and we're going to take up item number 14, adoption and proposed amendments to Regulation 18361.4, probable cause proceedings. A table in front of us here, we have Senior Commission Counsel John Fazer. Mr. Fazer, go
Yes.
ahead.
Thank
Good
you,
morning.
Chair and Commissioner. Commissioners, good morning. I'm John Fazer with the Legal Division, here to discuss proposed amendments to Regulation 18361.4. As you recall, the Commission requested that staff present recommendations to limit delay in the completion of probable cause proceedings. At the January meeting, we presented amendments for adoption. The regulated community, particularly the CPAA, expressed some concerns, especially about removing pre-conference records production. The decision was made to give everyone more time to provide input. On February 10th, we met directly with CPAA representatives, and they reiterated their opposition to removing records production and asked us to keep the current procedure intact. In response, staff has prepared two versions of the regulation. Then on March 10th, CPAA submitted its own proposed language, which we will refer to as version 3 for discussion purposes today. I'll briefly summarize each version. Version 1, the version that staff recommends for adoption today and was presented in January, removes the record production procedure, removes the provisions for witnesses, additional participants, and post-conference supplemental evidence, and keeps the firm probable cause conference deadline, which is 75 days after request for conference, plus 14 days, with extensions allowed only by mutual agreement. Version 2, which staff recommends as an alternative, keeps record production exactly as it exists today, but it's renumbered for clarification purposes, removes witnesses, additional participants, and post-conference evidence, and keeps the same conference deadline, the firm conference deadline. Version 3, CPAA's March 10th proposal, keeps record production, keeps the firm conference deadline, keeps witnesses and additional participants, and removes post-conference supplemental evidence. All three versions adopt the firm probable cause conference deadline. The only differences are whether records production and witness participation stay in the regulation. Staff recommends that the Commission adopt version 1 today based on prevailing legal authority and the purpose of probable cause. The California Supreme Court in Cooley versus Superior Court clarified that a probable cause hearing is a preliminary gatekeeping step. It serves to weed out groundless or unsupported charges and to relieve the respondents of the degradation and expense of a trial. Like a criminal preliminary hearing, the only purpose of the probable cause conference is to test the sufficiency of the Enforcement Division's allegations. It is not a trial, it is not discovery, and it is not the place to litigate admissibility or weight of evidence. Also, as a practical matter, the probable cause process does not have a mechanism to resolve evidentiary disputes or evaluate the relevance or admissibility of evidence. But the formal APA process does. Full discovery, witness testimony, cross-examination, and resolution of evidentiary disputes are all guaranteed in the APA hearing after a probable cause finding. Regarding a respondent's due process rights in the probable cause process, Commissioner Brandt noted in the January meeting that the proper question here is what process is due at this stage. A probable cause finding does not deprive a respondent of life, liberty, property, or even of a finding that the respondent violated the Political Reform Act. Under prevailing legal authority, a respondent in a probable cause proceeding has no right to records production or witnesses. Therefore, removing these provisions from the regulation would not deprive a respondent of any process that is due. Government Code Section 83115.5, the statute that controls and authorizes this regulation, requires only three things: notice, a summary of the evidence, and an opportunity to be heard. It does not require the Commission to hand over its entire investigative file. Some have noted that records production is needed to avoid reputational harm from a probable cause finding. In practice, however, there is nothing to indicate that records production prevents a probable cause finding. As explained in our memo, records production has been requested in only 37 of 206 probable cause cases between April 2020 and October 2025. Those cases required approximately 790 staff hours. Staff and hearing officers have observed no difference in probable cause outcomes between cases with and without records production. Also, a probable cause finding is not necessarily the first time a case becomes public. In most investigations, the relevant records are either public documents or materials already in the respondent's possession. Therefore, in most cases, the investigation and the allegations are already public before the probable cause conference occurs. When a probable cause finding is announced, the regulation requires a statement that the respondent is presumed innocent until a violation is proven in a subsequent proceeding. Therefore, the real protection against an unwarranted reputational harm is the full formal APA administrative hearing that follows an informal probable cause conference. In sum, the current records production and open-ended scheduling procedures create unnecessary delay, expense, and confusion about the limited nature of probable cause. Now, version 1 places the probable cause proceeding where the legislature and the California Supreme Court intended as an informal preliminary check on the Enforcement Division's allegations, not a mini-trial. These amendments do not remove any due process rights. They simply ensure those rights are exercised at the legally appropriate stage. I'm available to discuss any questions you might have.
Thank you, Mr. Fazer. I'm going to hold my comments until we hear public comment, if any. Commissioner Brandt?
Can I ask a clarification on
Of course.
the hours you said the cases since 2020? The hours that did, is that total or average?
Those are total.
So that's,
not average.
and that number is for how many cases? Sorry.
That was 37
37 cases and
790 hours.
okay, so that's 20. Okay, thank you.
And that's about 20 per case,
Yeah.
right? Is that what Commissioner Brandt mentioned? And is that reflective generally of how long it takes to conduct document production, 20 hours?
It is, yes. I mean,
Okay.
I don't handle them myself. I've done civil litigation and civil actions, and honestly, that's on the conservative side for civil actions. But my understanding from enforcement is that is very accurate.
Okay. And then what sort of hearing was at issue in Cooley when they mentioned when they looked at probable cause? So it was a
Yeah.
probable cause hearing proceeding. Was that before an agency, a court?
A court. It was before a superior court. Its allegations determined whether a sexually violent predator should remain in custody until a full civil commitment proceeding occurs. So it does involve a person's liberty. So it's actually, there's, I would say, more at stake in those proceedings than there would be at a PPC. We're not holding anybody. So that's very comparable. It's under the California Supreme Court and obviously our state, under state law. So it's very comparable to our probable cause.
Thank you. That's helpful, Mr. Fuzzer. Do we have additional, okay, do we have Commissioner Ortiz?
I appreciate the work you have done in trying to reduce opportunities unnecessary to delay finding a probable cause. Regarding timeline, I support the proposal to limit conference scheduling extension to 75 days plus 14 calendar days, while allowing an extension if requested by both sides. I think that part is really important. Regarding witnesses, I wonder why we're eliminating this if such requests are extremely rare. Regarding records, I have serious concern about this proposal. In 2020, according to your memo, the Commission discussed and adopted comprehensive amendments. Was the elimination on conference records productions considered at that time?
It was considered internally among staff, but we never presented it to the commission at that time.
So there was no decision whether to eliminate it at that time in 2020 with majors amendments?
There was no decision that was proposed or
Okay.
suggested to the commission at that time. It was internally discussed. There were lots of changes made to the regulation in 2020. And that was considered, but it wasn't part of the proposal.
Okay. My concern is whether This elimination is unfair to the respondent. Although it is stated on the item that records don't influence a decision of probable cause, and that the decision is based on the Enforcement Division's summary of evidence, it will appear a decision is presented from one side, negating the respondent's ability to challenge with their own records.
Thank you, Commissioner Ortiz. Since we brought up the 2020 amendments, what was the process for developing those amendments to the probable cause regulation? And specifically, I think it'd be helpful. So was that I assume that was a commission driven proposal? And did we meet in committee before adopting those changes? Or did we go straight to the commission similar to the lead that we did here?
I don't recall if there was a committee, but all I can say is that document issue was discussed internally. There was a complete overhaul. For instance, the subdivision A of the current regulation states up front what the standard for probable cause is. That standard had been buried in the last subsection of the regulation, and it wasn't even stated as clearly as it is here. So we had to move. The whole regulation was difficult to follow. There weren't specific dates that were guiding everybody involved how to proceed, and so there were a big overhaul, and so the records issue would have just been a big thing on top of things that we were doing. And for whatever reason, the decision was made at the time.
Okay, that's helpful. I looked into it myself. It looks like we had 3 law and policy committee meetings before this went to ultimately the commission for adoption, and the amendments changed. It seems quite a bit from what they originally were through that process based on public comment.
But can I
Commissioner
just
Brandt?
clarify, though, that
Sure.
this proposal about production was not part of those law and policy committee hearings? In other words, it wasn't, the committee said, oh, we don't want to do that. It was considered by staff, but not considered by the commission or the.
Sure, I
committee.
can't speak to that. But what I can speak to is there are proposals to eliminate providing exculpatory and mitigating information, and those were ultimately included in the initial versions of the regulations, and the Law and Policy Committee opted to remove those provisions because they wanted to make sure that the respondents had access to that information. If that's incorrect, please clarify.
To your first question, those regulations back in 2020, to my knowledge, I didn't have to wear these things back in 2020 when I worked on this. But they came about by staff, largely our hearing officers and some enforcement staff, identifying issues with the enforcement processes, the probable cause process and some of the other processes. In this instance, these changes are more driven by a staff request to speed up the process of probable cause overall. At the time, we were trying to address some of the issues we had seen that frankly made it hard to conduct the hearings because there was a lack of guidance in the regulations. As to mitigating, my recollection is where we ended up is mitigating evidence was no longer required. It was just exculpatory that would still need to be required. That was sort of the compromise position that the commission reached on that issue.
That's helpful. Why don't we hear public comment? If any? Just one, go ahead.
Hi, James Carson on behalf of the California Political Attorneys Association. Can you all hear me okay?
Yes, we can. Go ahead.
Thank you. First, I'd just like to say we appreciate staff and the commission's work on this process. We obviously do not see eye to eye on the final recommendation by staff, and instead have submitted our alternate proposal, which I think we're calling option number 3. We appreciate Commissioner Ortiz's comments earlier, and I just want to build on those very quickly. Number 1, this is a question of fairness, and I want to center our discussion around this probable cause determination and the timeline of investigation. This PC determination comes at the end of the investigative process. Staff has been reviewing these questions for sometimes multiple years. The opportunity for the respondent to then see the evidence that staff is relying on to come to their PC determination is critical for respondents to be able to respond properly. In fact, in the opportunity for respondents to respond to the PC report, the regulations require us to include evidence in our response why PC should not be established. And oftentimes, that evidence that we need is in the possession of the FPPC. I want to highlight again, this is staff's own conclusion. There are only 37 cases where respondents actually went through the process to request this evidence. So this is a relatively small subset of cases that come through this process. And we understand that there's some additional administrative work to produce that evidence, an additional 20 hours. But our view is that 20 hours over the scope of investigation that takes 3, 4, or even 5 years is negligible, and that it's important for respondents to be able to review, see the evidence put before them, and be able to respond in kind at the PC stage. We also feel that same way about witnesses. Again, a relatively small number of cases will involve witnesses at the PC stage. It's important for respondents to have the opportunity to, again, confront the determination of probable cause. Because while staff classifies this as an informal proceeding, it's only informal in the sense that it's conducted not under the confines of an APA hearing. That APA proceeding and hearing is by far the most expensive, time-consuming process for both sides. And having the opportunity to review the evidence, present witnesses at the PC stage, allows both sides to test the validity of their case and hopefully come to a more efficient resolution. So this idea that, rights will be protected down the road in an APA hearing, now after an investigation has gone on for several years, an APA hearing may take several more. There's a real timeline issue here where, if we can have off-ramps earlier in the process, including at the PC stage, to try and reach a settlement, having the opportunity to review that evidence and present witnesses at the PC stage is still important to that process. Lastly, I'd just like to say and reiterate, we've talked with our members in CPAA, and so our position is that the retention of the records and the witnesses are crucial. The changes to the timeline, we still view the existing law as a good compromise, frankly, that any extension requests have to be evaluated based on a showing of good cause for both sides. We think that remains appropriate. But in the interest of compromise, we submitted our version 3 as a way to try and move this process forward. So we are happy to answer any additional questions that folks may have, but simply want to reiterate that there's nothing informal about the PC determination. There's a formal declaration of the commission. And while there may be a statement that says, presumed innocence, there's a public declaration that the Fair Political Practices Commission believes there's probable cause for a violation to occur. And that becomes public, and that becomes potentially something that candidates, committees have to deal with sometimes for years before something can be resolved through an APA hearing. Thank you.
Thank you, Mr. Carson. Do we have any additional public comment? Mr. Fazer, would you like to rebut any of the arguments set forth by public comment?
Well, this all just comes down to the nature of the proceeding. If there's a disagreement over the nature of the proceeding, there's no mechanism, as I stated earlier, there's no mechanism for an evidentiary dispute. And so how does that even, how do documents even get, if there's no motion to compel, there's just no procedure for it. There's nothing, we'd have to set forth a whole another procedure. That's the thing. This has come up a couple times where I've been the hearing officer, and there is an evidentiary dispute, and I just make it up.
So when the last couple times that it's come up, what has legal division pursued to resolve those sorts of disputes where you don't have direction?
Well, I'm the hearing officer. I just sort of make up guidelines based on my experience as a civil attorney in dealing with the evidentiary disputes and civil actions. But there's definitely nothing in this regulation that calls for dealing with that. And then every time it's happened, they're completely irrelevant. The documents are completely irrelevant to the issue at hand, which is the standard that's at issue for probable cause. Completely irrelevant.
That's helpful.
Okay.
Okay, so before we move any further, I'm going to disclose my ex parte contacts. If any other commissioners have ex parte contacts to disclose, I think that'd be helpful at this stage. And then I want to open it up to questions from commissioners so we can delve into this further. So I spoke with James Harrison and Olson Remcho, Catherine Baker, a former FPPC commissioner, Honorable Rich Matich, former chair of the FPPC, Bob Stern, Robert Stern. I was one of the framers of the act and a LA City Ethics Commissioner. I spoke with Mr. Carson and Nielsen Merksimer, as well as Casey Jenkins at Bell McAndrews, Tracy Wigglesworth and Nick Sanders at Political Law Group, and Gary Winnick of Kaufman Legal Group. I found these discussions to be helpful, to provide insight. I think my takeaway is that we have sound legal arguments why this isn't appropriate. Why a lot of these different aspects, if not all of the aspects of this regulation, are appropriate in this type of proceeding, right? But what I'm missing are facts, actionable facts. And this is something that Commissioner Wilson pointed out at our Chico meeting. There are going to be questions as to why the FPPC is pulling back due process protections that it created unanimously in 2012. I 100% agree. I think we're all on the same page, or at least I'm on the same page with staff. It sounds like Commissioner Ortiz has some questions in terms of witnesses. I can tell you that from my personal experience, I feel like including witnesses in PC conferences can be a distraction. I think it can complicate scheduling and delay these proceedings, right? So that we could get the information that's necessary to the public. I also think that in my experience where I did PC conferences where I participated in them, where there was a witness, the information that was provided was wholly irrelevant to the actual violations that were before us, let alone the actual determination in this matter that's provided by our regulation, right? Here's the issue. When the public comes to us, when someone who decided that they wanted to run for office and now they're a PC and they thought that they could bring witnesses, but we're changing the rule now and we have to explain it to them, we're going to tell them that, you know, we felt it wasn't appropriate. I don't think that's enough. I think what we want to be able to say is we've had probable cause conferences for the past 5 years. This amount of them have had witnesses, right? Of those witnesses, 98%, 100% have provided testimony that's wholly irrelevant to the violation at issue, to the determination to be made. That's facts. Those are facts that we can provide to the press, good government groups, as to why we're taking this step to remove due process protections. You know, Commissioner Brandt mentioned what is due at this stage, right? What is due under the statute, right? There's very little guidance in the statute. The commission adopted regulations in 2012 saying what is due, and we're removing them, right? That's a serious determination. We are considering removal of them for extremely important reasons, because the due process protections, they can impact timely enforcement of the law. But as regulated community has pointed out, they can also impact fairness in these proceedings, at least in their opinion. And what we need to do, in my estimation, is get the facts, the information necessary for us to counter those arguments. I'm not comfortable with us saying, you know, there's no benefit to providing you with these documents. You're not going to find them useful at all, and not having actual facts. Or there's no benefit to having witnesses. I'm the chair, I did 2 PC conferences and the witnesses weren't helpful. I would like to flush this out further, personally. I think we should take a similar approach to what we did last time that we amended these regulations, or this regulation. And I think Commissioner Brandt and I should take this to law and policy, and we should look at the whole process, essentially how we looked at enforcement streamline prior to considering our streamline regulations next month, and identify what needs to be changed. It sounds like there's a lot of changes. In my estimation, I think there is to this process, and what facts we can point to as why we're removing these protections for folks. I need to acknowledge as chair that I pushed this along pretty quickly because I felt that it was urgent. To be frank, I was frustrated And I felt like I was justified in being frustrated. And that's because at the very least, it appeared that this system was being gamed in a way that would withhold information from the public, and additionally, would place the blame on our hardworking enforcement staff and commissioners who are here solely to make sure the public has this information and get cases done as quickly as possible and hold people accountable, right? So that's on me. I think that we should follow the lead of past commissions and take this up at Law and Policy, look at the facts. I'm more than happy to flush out specifically what I would like to look to. So the witnesses, for example, I think that would be excellent data for us to have. Second of all, whenever we try something new, whether it's the prep program, streamline, or heat map, new technological adoptions, we always look at the best practices across the state and the nation. You know, legal division may have already done this, have already looked at what the FEC does, what their process is exactly, what other commissions in the state of California do. That's not something that we've considered as a commission on this item. And I think it would be incredibly helpful for Commissioner Brandt and I to see what the FEC does, and then see what good government groups, what other groups have said is most effective, and whether the FEC's approach is effective, and what those groups think of our approach, so that when we make these changes, we're not back here in several years making additional changes. With that, Commissioner Brandt.
Okay, so first let me start with a couple of questions. You just said of those 37 cases, none of the, and I'm focused on documents. So witnesses, you know, I don't think I have much to say. I don't think they're necessary, and I understand if we don't have anything there, there's never been change. So I want to apply the similar kind of question to the documents. Have there been cases, and I would invite the public commenter to chime in here, have there been cases where you produce documents in those 37 cases and suddenly, oh, well, there's not a probable cause? Are you aware of anything from, I'm going to first ask staff, are you aware of any cases where document production led to change in the outcome, or, you know, in any way?
In my experience as a hearing officer, not as an enforcement attorney, no. In fact, if you read the standard and the requirements in the statute and the regulation, my sole focus as hearing officer is to look at the allegations that are made. And that's the question. And so this outside evidence isn't even relevant to the question. Not even relevant. Now, if there could be some circumstance, I suppose, in some hypothetical situation where you could have some smoke again situation, but I would hope in those circumstances that enforcement wouldn't even bring the allegations. And maybe that's happened as far as I know, but it doesn't get to me as a hearing officer.
And they get the respondent gets a summary of the documents that we have, right?
Of the facts and allegations, right?
Okay, so and it includes more than just the facts and allegations, but it includes, here's a summary of the documents that support those facts and allegations.
Yeah, it would include the content of documents that support the assertions.
And in those 37, are there documents that the respondent didn't have? In other words, did investigations, is that something that, wow, we have this document, or were they documents that were from the respondent, or in some ways related to the respondent that the respondent had?
My understanding, and I might need some help from enforcement on this, but my understanding is that in most cases, and maybe not all cases, somebody else could comment on that, but in most cases, it's documents that are already in the possession of the respondent, or public documents that maybe the respondent didn't have, but they were public documents.
Could I ask for somebody from enforcement to join him at the table? Is that possible?
Of course.
Okay, thank you.
And just to clarify, so if someone requests document production, we provide summaries of all the documents that are held by enforcement? Is that what you were saying?
Don't they provide summaries already without document production?
We'll go, Chief Bonebrink?
So in the PC report, we provide a summary of the evidence.
Okay.
That doesn't necessarily mean that we go through document by document and explain what is in each document.
Okay.
In the event that they request documents as part of the PC process, at that point, we will go through all of the documents. Most of those that are provided, as you mentioned, the specific sample that I looked at just the other day, most of the documents, if not all, were previously in respondents' possession. At that point, the documents that we provide as part of the PC process, we will provide the document and a list of the documents. We do not summarize what is in the document.
And then so this is at the end of the investigation. So in investigations, are you talking to the respondent or the respondent's attorney?
Absolutely. We try to engage throughout the entire process. Our goal is to work with the respondent and the respondent's attorney to settle these matters. And so at any time during the entire process, we want to be open and share with the respondent or their attorney any information that we think would be helpful for settlement.
And how many probable cause conferences do we do a year?
I don't know the answer to that. I would have to get back to you.
But, I mean, is it 50?
I haven't been here long enough to
Okay.
know the average.
General counsel?
Yeah, I don't know the exact number. It's a handful, I'd say, where we actually have a hearing. Usually the probable cause is handled on the papers.
Okay. Well, and I'd say for me, I would go with staff's recommendation because having been an attorney more in civil litigation, and it's, early on, you're doing that, and it goes back to my comment about what processes do. And I think at this point in the process, I'm not convinced that they need more than the summary of evidence to get the documents. Because I like you, I haven't heard any facts. I mean, actually, I want to ask the commenter, do you have any facts? Are there cases? Have you seen cases where, wow, we get this document from one of these 37 cases, and suddenly it changes the whole nature of the investigation?
Yes, James Carson on behalf of CPAA. Can you guys hear me
Thank
okay?
you. Yes, I can hear you, please.
Yes, happy to respond, Commissioner Brandt. Yes, we've had members report that going through the PC process, receiving the evidence, and I want to make clear, there's a big difference between receiving a summary of the evidence and actually receiving the documents, especially after staff has been reviewing for multiple years. Staff may miss something, staff may view an email differently than the respondents, and those, and the analysis that comes from that, from the respondent side, is crucial leading towards settlement. So, responding to your question, Commissioner Brandt, yes, we've had members report that after documents were turned over in the PC process, that exchange actually led to settlement. So it didn't go through the full PC determination. It became an off-ramp for the case to be settled. That it didn't have to go through PC, didn't have to go through an APA. And just on the question of basic fairness, right? As we've identified here, this is a relatively small number of cases, only 37 of them where records have actually been asked to be produced. I'd also like to highlight, again, the regulations are not asking staff to turn over their whole file. It's only turning over evidence that is in their possession, that is not in the respondent's possession. And those are exactly the types of documents and evidence that we as respondents need to see and evaluate to push towards settlement or to push towards a resolution at the PC stage. Does that help?
That helps. And so you say, so are we talking, how many members have reported that led to settlement or something else? So I heard you had members. Can you give me some range of what that number you've heard from?
We didn't take a formal poll. That example that I gave was from one specific member. So that was one instance. But I'd like to point out here, we are ultimately talking about edge cases in these processes, right? This is 37 cases out of the over 200 that actually go to PC where the evidence is even requested. The chair shared his personal, process with the personal engagement with the PC process and experiences with witnesses. A lot of this is anecdotal evidence, and there's not a ton of data, because ultimately the types of questions where this becomes a real issue is relatively small. But we think in those circumstances, as the chair was pointing out, there's a big question of fairness. And right now, what staff is proposing to do is to basically say, take our word for it. We've been investigating this for 3, 4, 5 years. Here's a summary of the charges against you. Now go to an APA hearing and then we can duke it out. And that's just simply not fair. And all we're asking for is to retain the existing process, which requires staff to show their work, turn over the evidence in their possession when it's requested, and let respondents have an opportunity to respond to that at the PC.
And just to clarify, just one moment, Commissioner Brandt, I just want to make it clear that I don't necessarily agree with the assertions that are being made by the regulated community in terms of fairness. What I'm pointing out here is that we have one side who's saying, we have several members who've reported that after getting these documents, I don't even know necessarily if that's what they're saying, but they're saying at some stage, getting these documents has assisted us in either settling our case, getting a case rejected, what have you, getting a case closed. We have staff saying that there's never been a circumstance where that's been the case, or at least in your experience, right, Mr. Fazer?
As the
As
hearing
the hearing-
officer.
As the hearing
Hearing
officer.
officer,
Yeah.
right.
Right.
Which is different than, and that's why, I don't know whether Chief Bonebreak may have other perspective on that, but yes.
But
Okay.
I think this is just indicative of what I highlighted. Like if we go back to law and policy and we say, CPAA, you really believe that there are circumstances where you were provided evidence that resulted in settlement or a case being rejected, tell us those cases. We want to look at those cases. And if that's not true, I think that gives us tremendous insight as to how we should be moving forward with this. I think the converse is true as well. I think we talk about how initially it's my understanding that part of the reason why we adopted these regulations in 2012 was because we felt that if we gave the records to respondent, that it would make them more likely to settle. So for example, I looked at one of the responses that were provided to a pro per respondent who was taking this conference. And we included in that documents that wouldn't be available to her, right? That specifically the FPPC call log that said, hey, we called you on this day, we left you a voicemail. We called you on this day, we left you a voicemail. That might not be enough for that person to decide to settle their case after that, but it also might be. They might think, well, I don't even know if these people really called me, and then they see this record that demonstrates they did, and that could lead to settlement. If we don't look at the timing of settlements right after PC, then we can't really speak to the facts and the record as to what's going on here. Again, I believe staff's legal reasoning is absolutely sound here. I just want to make sure that if we're doing anything where the phrase due process is mentioned, that we can point to the public, this is what's going on. These are the facts. We looked at this deliberately. We considered all the information. We considered the other side's argument. And to the extent that we go ahead and adopt these changes, we felt that their arguments weren't based in fact, and that's why we moved forward with these specific changes to the law. I think that's the best way to do this. I think that's what we've done in the past, and that's what I'd recommend here. But Commissioner Brandt?
Okay, so I want to engage CPAA further. I'm hearing fairness. I'm hearing, it makes sense for settlement. But I'm not hearing that you think that as a constitutional matter, you're losing due process, that there is process, that you have a right to this stuff at this stage. Is that, am I hearing you right? That you're not asserting that you have a due process rights to get this material before a probable cause hearing. Is that right? Yeah, no, I said to CPAA. Yeah, he's coming.
Yeah.
Go ahead.
I'm here. I'm unmuted now, I believe.
Okay.
Well, the due process right exists there in the regulation. So we're not. I don't want to get into a discussion about sort of due process globally. If we want to have a conversation around what the statute requires, what the regulation now requires, I think we could do that at a later time. But the fact of the matter is, the process that's in place, staff is proposing to change it. So the regulations currently say what they are. That is the process that we are currently entitled to. We think that that is, on the whole, a pretty good process, but are willing to discuss changes around it. But in terms of a, what should the level of due process be in this context, that at that point may be getting to, legislative changes. And that's not what we're talking about here. We're talking about the regulatory standard that's been in place since 2012.
Okay, I hear you. But I would say then that there is we are giving, even if we take away production of documents, we are giving you process what is due you. And there's not some constitutional right, if we can't go to probable cause hearing without these documents. That's my view. And so whether you're going to take that position or not, I'm responding partly to your previous letters saying, oh, you're taking away our due process rights. Kind of a vague comment, but that's where I wanted to say what process is due. And I don't see anything that's due here. And I just, okay, I could imagine going to committee, and maybe then we ask you to go and pull your members. How many have you had a case where it led to settlement or something like that? And maybe that makes sense. But I'm ready to go today to the staff recommendation. But right. I'll leave that to you. I mean, I don't know whether
may I just
have the
respond?
votes. Sounds like.
Thank you, Commissioner Brandt. Commissioner Wilson?
Right. I was going to say, the points made by Commissioner Brandt, I think were right on point. And then Mr. Carson with CPAA made some excellent points as well. My recommendation is that the Law and Policy Committee should look at this matter, have a hearing, and if feasible, anyone who's testifying, that they do it in person, because I think that has more of an impact as opposed to doing it on the phone or doing it via Zoom, given the seriousness of this particular issue. And then I think we also need to look at what are other agencies doing? Not necessarily the Federal Elections Commission. We have the San Francisco Ethics Commission, Los Angeles Ethics Commission. How do they handle probable cause hearings? Because you could have a situation where, someone has got a case pending in San Francisco. They also have a case pending before the FPPC potentially. What kind of consistency is there? And I think we ought to look at those issues because potentially we have a PR issue. If the summary of our action is, FPPC reduces rights in probable cause hearings, then we're trying to explain why that's the case. Because kind of what we're talking about now is really like inside baseball. And unless we have a public hearing, in my opinion, where people actually hear the pros and cons, then I'm not prepared to support this until all those issues are flushed out. And I support the recommendation, with all due respect to Commissioner Brandt and the chair's time, that this issue be discussed at the Law and Public Policy Committee meeting, and then we can move forward. But that's just my position.
Commissioner Ortiz?
No, I agree with Commissioner Wilson's proposal and your proposal to further explore and discuss the ramifications of this proposal. This is important. I mean, this is not a light thing. I mean, as you said, how do you explain that to the world? And so based on facts and based on the discussion from both sides, I think that's the best solution.
Commissioner Brandt?
Okay, so sounds like you have the votes for sending it to committee. And that's fine. And so then my comment would be the things I need to hear, because I actually want to respond to your comment, Commissioner Wilson, about what's said out there. So I want the CPA attorneys to decide, do they really think they have a constitutional right to due process? Are we really reducing their due process rights? Is that what's going to show up on the front of the LA Times? Commission does that. I think that's right. I think it's also good to look at what the other commissions are doing. But I don't want to be a model of the Public Utilities Commission, which takes years and years and years, and they have all these different things. But I think that's right. Let's look at the Ethics Commission. Let's look at how they do this, because they are also different when you're dealing with a public utility, for instance, and they're a huge corporation and there's millions of dollars and all those kinds of things. We're dealing with things, ethics commissions are similar because we're dealing with public reputation. And so that is, I don't necessarily concede this, but that is there has been a court who has said that reputation is a life, liberty, and whatever it is. Anyway, but so I'll acknowledge that. So that's why if we're going to do this, then I want CPAA to go poll their members and give me specific numbers. How many times this has happened since of these 37 cases that this has changed wherever they went with it. Okay, I want them to clarify what their position is. Is this due process, as you said, under the statute, so that we could change it? I mean, and the statute doesn't require us to do certain things, so we're changing regulations. So you're claiming the due process rights under the current regulations, which are not required by statute or the Constitution. And then finally, I want to hear more from kind of the stuff you, Mr. Chairman, you talked about from enforcement about what kind of things, give me some real sense of what this is. And I think that's fine. So since I'm on the committee, yeah.
Of course, Commissioner Ortiz?
If one of the issues that you're going to put on the table is the constitutionality of this issue or not, I think I will also add fairness to the discussion.
So that we can be claimed to be unfair if I mean, the commission is being unfair. And maybe that's right. I mean, maybe but then we have another argument on the other side to say, yeah, this has been going on for a long time. They're going to have a hearing. They have a right to an ultimate hearing if they want to. And so we can make arguments about that fairness.
Put all these questions on the table.
Okay. I'm good with that. But I think that then you need to come, CPAA, to the table with why is this fair? Why is this fairer than you doing this? Because I mean, document productions.
Build on what Commissioner Brandt said there in terms of CPA, not just CPA, but
right.
Government groups, whoever is impacted by this. If we don't receive any evidence, we're going to assume there's no evidence. And I think that's reasonable.
Right.
Do you agree?
I agree. Completely agree.
Okay.
Yep.
So what I would propose at this juncture is we move on to the next item, right? And then at the end of the meeting, for items for future discussion, we give direction to legal division as to how we would like to proceed in terms of the law and policy meeting. Would that be appropriate? Or do you need a motion?
I would like to do a motion.
No, I think we should do timeframes, but I think we should lay out timeframes as well as specific factual information that we're looking for, as well as the process that we want to better understand. I think we should be as specific as possible, but I guess what is the appropriate venue for providing that information to legal division? In a motion on this item or in a motion on the last item for items at a future agenda?
So I actually feel strongly that we should do a motion on this item because I want to have that motion. And actually, I think we can wait until after lunch or something because I'd like some assistance on this. But I want to identify the things that we expect and put it in a motion that these are the things we expect from anybody who's interested in this party. And your statement that we expect evidence. And if there's not evidence, then we're going to assume that there's not evidence.
Okay, but just to be clear, at the lunch period, that would be something that you would do on your own without
Right.
talking to other.
Correct.
And I would as well.
I would,
Do
right,
that on
and I
our
would not, right. No, I need to get from staff some things about dates and other kinds of things.
And then you'll bring the motion to the full
Correct.
body. So in that context, one of the things I would recommend is that our new website is just, it's so exciting. The only challenge with going to it is you don't want to get off of it. It's that good. But I also think that motion that that's being proposed by Commissioner Brandt, that be included in the notice for the meeting. So that if somebody says, oh, I want to, watch a policy committee meeting, when they open up the meeting notice, they'll see the actual motion that that Mr. Brandt is recommending. So I'm not going to call you Alf. I'm determined not to do that.
Okay, so we plan to take another recess at 12:15. So How do you propose, so I propose that we move on to the next item, and then when we return from recess, that we go back to this item, we entertain Commissioner Brandt's motion.
Good enough. Yep, that sounds good, like good plan.
Okay. Thank you, Mr. Fazer. Thank you, Ms. Bonebrake. Okay. Okay, we got our CIO, our Chief Information Officer, coming up to the table, so I assume that means we're moving on to our website, which is item number 15, launch of new FPPC website. We have here our Chief Information Officer, Jesse Hidalgo, and Education and External Affairs Unit Manager, Chloe Hackert. Good morning, folks. You're two of the busiest people here at the FPPC. I'm going to lay that out front and thank you for all your hard work as we've launched this website. I've only received, for the most part, tremendous feedback. And I got to tell you, I love using the website. The new website search feature is really remarkable. It makes it so much easier to search through advice letters, enforcement data, agenda items. So for instance, you can just put in a specific code section to a search. I'm sorry, I'm probably ruining the presentation a little bit, but
teasing it away.
it's amazing. So you put the code section in there and you can select specifically administrative fines. And right there, you have every single one of the administrative fines that we've levied that we have documentation for online, electronic documentation that you can look through and review. It's incredibly impressive, and both of you should be proud of this project. The whole staff of this agency should be proud. Public probably doesn't know this, but at several different points in producing this new website, every single staff member, including the person talking, was involved in reviewing and adding data to the website. So I'm very proud. I'm very proud of the effort everybody put in, and thank you so much for all that. So with that, sorry to steal your thunder. I think Ms. Hackert, you're going to start us off.
I am, thank you. Okay, it is 11:59, so I can still say good morning. Chair Silver and Commissioners, my name is Chloe Hackert. I am the Education and External Affairs Unit Manager, and with me today is our Chief Information Officer, Jesse Hidalgo. So as Chair Silver said, we're presenting on the new website today. Last month, the FPPC officially launched our newly redesigned website. We also unveiled the new website and its enhanced search features at the February 12th Public Outreach and Technology meeting with Chair Silver and Commissioner Wilson. As Chair Silver said, the FPPC has been working hard behind the scenes for the past year and more to bring users this new website featuring enhanced search features and tools to make it easier to locate and review campaign finance data and ethics information. This update is part of the FPPC's ongoing work to improve its digital systems and expand public media and regulated community access to information about political activity in California. Now we will demonstrate some of the exciting new features of the website. So I am sharing my screen right now. Hopefully you all can see it. So we are still at the same location. So our URL has not changed. We are fppc.ca.gov, but some things have been moved around for optimization and better organization. So first thing I'm going to be highlighting is that we have a new layout. These are the 7 tabs found at the top of the website. They're in the blue banner. As someone who is on phone advice, if you get me, this is usually how I am navigating people to find things through the website by these top 7 tabs. So the first one I want to highlight for you today is filing officers. So this is a new tab that we created because filing officers are one of our largest stakeholder groups who access our website. We move their pages out of the Learn tab into their own tab. So they have all their pages information in one location for the commonly accessed information. So they have centralized access to guidance, tools, resources related to their statutory responsibilities, including public access to disclosure statements, compliance, review of statements for accuracy and completeness. Additionally, here is where you can find information on the conflict of interest code rules and exemptions. That also is moved out of the Learn tab. The next one I want to cover is search filings. This was formerly known as the Transparency Portal on our past website, and we renamed it to Search Filings. It provides the same access to filing and disclosure information as before. It just has a new name. This is where you're going to find some of our most common searches. So this is the Form 700 search portal is housed here. And this is where you can view Form 700 searched by file forms with the commission by 87200 and 87200.5 filers. To tease later, we'll be going over some new enhancements there as well. We also have on here, we moved out of this, the heat map. So now the heat map is found under the Enforcement Division tab. This way, all the enforcement information is found together. And people, if they want to look up what cases were prosecuted in their county, they can do so now under the Enforcement Division tab. Additionally, another change we made is that we now have a Contact Us tab. On our old website, if you wanted to contact us, all our information was distributed throughout the website. It was about FPPC, it was in the toolbar. Now we have a centralized tab that has all this information in one location. So people can come here to join our mailing lists. I encourage that if people want to stay up to date, again, back on our old website, that was in the toolbar. And if they want to have information on how to contact our advice programs, or if they want to file a California Public Records Act request, that is all here on the Contact Us tab. So those are some of the new and highlighted features I wanted to show you today about our new website to streamline searches and make things easier for the public when they're looking for us. But as Chair Silver talked about, one of the most exciting features we have is that the enhanced search. So this is the search page on the FPPC website. You can find it by clicking the search tab, and then you will use this search to find your search features. If you're looking for something, you can just type it into this search bar and click this, and you'll be able to find what you're looking for. But something that Chair Silver talked about that we put a lot of man hours behind is that we updated, to use Commissioner Wilson's term, inside baseball, the taxonomy. I didn't know what that meant when we met with our IT people, but when we finally learned it, it's all these filters on the right-hand side. You can now, as Galena says, online shop for what you are looking for within the website. And so I wanted to highlight some of these that really help narrow down and help your search. So this is all done with the manpower of FPPC. We are tagging these documents, making sure that the search is working and people can drill down for what they are looking for in these ways. So the first thing I want to highlight is publication type. This is really going to help people find what they are looking for. So as Chair Silver said, if you want to look specifically for advice letters, you can just check the box advice letters, and it's going to take you specifically to results only tagged with that. Similarly, if you are looking for certain forms, you could check forms. If you are looking for administrative fine and penalties, the enforcement stipulations, you would just check that. And then additionally, if you are looking for press releases or anything regarding what we've put out as the executive staff, those are available here. Something else I want to highlight is that we try to include information by topic. So now if someone wants to learn all about candidates or campaigns, they can search by topic and then get all the information from fact sheets, manuals, all parlayed to them in that way. And so I will give a quick demonstration, kind of showing the back and forth of our old website to new one. I promise to get us out of here by 12:15 for our lunch break. So with our old website, this is what the entire, hopefully it doesn't, okay, there we go. This is what you would first find in the old website. And you had to use the advanced search options often to find what you were looking for, to drill down on those things. And we didn't have any taxonomy or filters. Instead, if you wanted to find those specific searches, you had to use the other searches on the right-hand side that are linked here for on the old website. So this is all embedded in our current search on our website. There is an exception that certain things housed on our own internal portals, such as the Form 700 search, behested payments, and the enforcement case and complaint information portal. Those are all housed on our FPPC servers, so those are not on our direct website, and those have their own portals that are linked elsewhere on the webpage, but everything else is accessible.
I follow your logic. Could you just explain the reasons for that delineation?
You want to take that?
Yeah, those, the behest payments and Form 700 are hosted on a different system. And this search, the new search on the website is based on all of the things in the current system that's just the website. So yeah, they're in completely different systems that do their own search.
Yeah, thank you for the clarification.
But back in the day on an old website, not that long ago, February 5th. You would need to, if you wanted to find enforcement cases, you would typically need to find it through the enforcement case resolution searches. And then if you wanted to find a form or a letter, you would need to use this search, which I would say is a little clunky and could be difficult to navigate. And so the new search we have on our new website, which we're thrilled about, I think is much more intuitive to the public and to the user. And while it might give you, it's a very smart search, it might give you a lot of information, you have all those filters on the right to help you narrow down specifically what you are looking for. And so I have an example on the last website. If you were looking for the Form 700 on here, the search results yield from 2018 a bunch of enforcement stipulations that might have done that instead of giving you the Form 700 or form. And on our new website, you could be like, I don't want to look at enforcement stips, I only want forms. And you could check the box form and it would give you only results yielding forms. Additionally, on the old website, this is the enforcement portal if you wanted to look for enforcement stipulations. Again, it's separate. In our new website, it's all together, so you can keep playing around with the search if there's more you want to look for. And if you typed in a case number from the agenda and want to find it, it doesn't give you exactly what you're looking for here. And some of the things we worked on with all staff working on it is kind of renaming our tagging. And so things are a lot more intuitive and matching across the website as to what you might see on a stipulation on agenda, you would see in the search that way. And so those are those. So I will give an example here. So that case was 14/346. So if I'm looking for a stipulation, I'm going to check administrative fines and penalties. I'm going to type in 14/346, click search, and it's the first stipulation that pulls up, and it has that in the title. And so again, the search is very fast and intuitive. It's going to pull things a lot easier than our past website, and we put a lot of work and effort into making sure that happens and took a lot of public comment and feedback from our past website to try to have a more intuitive, helpful search for users. So that is what we have for the demo. We also want to acknowledge that we have gotten a lot of public comment on the website, fairly positive. Everyone seems to be getting used to it, and we know it's new and exciting and trying to figure out how to navigate it all. So some exciting updates. We got some feedback that people missed some things on the old website, so we added back the all regulations to the regulations index. Just wanted to let all of the regulated community know this is very helpful for everyone. So a big shout out to Rieko Avaska and Amanda Apostle for making that happen. We also have received feedback regarding the new layout, and it's easy to find, and that the search is working, but we have gotten some comments on the Boolean search, and that's another inside baseball term that I don't know what that means, so I'm going to pass it off to Jesse for here.
Yeah.
And before we go on to Jesse, I just want to mention, as far as the Boolean search goes, I think that was an incredibly important feature of our last website. That's something that the Public Outreach and Technology Committee was able to secure, push for, and I think it's a great feature. And it sounds like, as I'm sure Mr. Hidalgo is about to lay out, that it's something that we're going to make sure is part of the functionality of our new website. Last thing, just because I think this is so helpful to the public, because I think most of the people that are coming to our website are trying to figure out how to comply with the law. Before, on our old website, if you put conflicts of interest into our search, you'd receive thousands and thousands of results, right? Here, you can do the search, you can narrow it down, just like Ms. Haggart mentioned, to fact sheets and conflicts of interest, and you have the FPPC conflict of interest fact sheet written in plain language that a council member can read the evening before their meeting where they're concerned about a conflict. To me, that is just like tremendously helpful in us furthering our mission. So I will stop talking about the website now. Mr. Hidalgo, go ahead.
Yeah, what we're seeing is the unique thing about the Boolean search when we do a search is, say you're searching for a term like commission advice. You put quotes around it, and it'll search for commission advice as seen in a whole thing. The problem or the unique thing about our site that is that's been brought to our attention is both the term commission and advice will show up in bold, even if they're not together. But that doesn't mean that it's only showing you the search results of the quoted term. So that's why. So the feedback we've received is that the Boolean type of search isn't working, but it is working. It's just showing you the individual words bolded, which other search engines like Google won't show you the individual words. They'll only show you the phrase bolded. So that's what's sort of unique about our website, and that's what we found. But that is, it's also an important thing to note that, this is new. It's a new implementation. And so the response from the community is important for us to get that feedback and to thoroughly research any solutions or any resolution to an issue that might come up.
And we're constantly working with our vendors still. So they're still on contract with us. They're helping us. So when we get this feedback, it's very helpful. So after we got this public comment, we thank you for it. We went to our vendor team and have tried to boost our searches. So things with titles that often people are searching for are now going to be coming up first and be more accessible to them, and to try to have a solution to it, because this is a new platform than our old platform. So it's a completely different search than what we had before on our different hosts. And so we're all learning it together, still exploring it, but I think it's going to get smarter as we use it more too.
Yeah. We've also added, you can search by date now, or by the most recent in the.
You can sort by date.
Yeah. Sort by, published date. Yeah.
Okay, great. I understand we had some public comment on this specifically related to the Boolean search. Hopefully I'm saying that right. If, he is not here for the commission hearing, I would hope that we're reaching out to that individual, getting their feedback and asking them how we can improve the website. As Ms. Hackert mentioned, almost immediately after launching the website, there were several folks who were concerned that they weren't going to be able to do the pull down all regulations at once, because a lot of us political attorneys will just put Control F, put in the term that we're looking for, and go to that reg. It's not possible if you don't have that all regulation. And that is something we've already responded to. So if you're frustrated with the website, please reach out to us. Don't just sit with your frustration. Is there any other, Commissioner Ortiz?
FBC has arrived to year 2026. So thank you.
Commissioner Wilson?
Yes, as a member of the Public Outreach and Technology Committee, I had the opportunity to hear the more, even the more detailed presentation and, that you provided us at our recent committee hearing. But I also want to just, commend Chief Information Officer as well as Ms. Hackert on the outstanding work that you've done. And I don't even know if this is feasible or even advisable. I would suggest that, perhaps you consult with our executive director as well as the chair, whether the presentation that you just gave could somehow be pulled out of today's hearing and provided as a link on the website, because someone who, for whatever reason, didn't hear today's hearing would be able to look at what in effect is kind of a summary of how to do it, how to access the website and how to use it. So something to think about. And also, Mr. Hidalgo's, team, also played a key role in making this happen as well. So thank you.
Yeah, thank you. There's good news about that video. We do have help videos that go over in more detail.
Oh, okay.
Chloe's team did a great job. And it's on the front page of our website, and it has chaptered views of it. So if you want to look at a specific type of a new feature or different from the previous website, then you can find that on the homepage.
Okay, thank you.
And just so I don't forget this, I think since we do have that and we went out of our way to create those video instructions, perhaps it would make sense to put that in the banner at the top, to embed that video in the banner. That's something we can, discuss after the meeting. But I think, it's very impressive you're able to throw that up so quickly, and I've watched it. It's very helpful. So I think the more people who see that, the better, because it's a little bit hidden. You have to go scroll down a bit to get to it.
Last comment. So I think my comment was going to be, what are the people who are most on this site saying about it? But you already answered that question. So I appreciate that, and I want to support doing that and responding to those who are on the comment radio and who experienced the last one. I think listening to that and actually seeking out that. But we don't need to go, one of those little boxes, will you take 3 minutes to, we don't need to do that because I think we've got an active, engaged in stakeholders. And so I appreciate you reaching out and responding to it. Thank you.
I like to print things. So we've already responded to the public comment, and we will continue to reach out if we have updates regarding searches, and we continuously update anyone that's reached out with questions. So this is the education email inbox. So if anyone does have issues accessing something, can't find what they're looking for, or is missing something from the old website, please reach out. We respond pretty quickly to be able to address your concerns or take it back to our IT department to see if it's something we can have a solution for. Lastly, I just wanted to say a big thank you. So as Chair Silver talked about, this was a lot of FPPC man hours that went behind this. And we had members of what was called a migration team that took our old website to our new website. And they dedicated 4 hours of their day to do this, to make sure it's one-for-one matching, up to date, all the documents tagged correctly so our new search will work. So I just wanted to give a big thank you to everyone that gave their time to do this. We also had 2 all-staff tagging days on Zoom. It was quite fun to have everyone together, and we had breakout rooms to go do this, and we were able to tackle so much in those 2 days to be able to launch on our target deadline. So it would not be possible without the hard work of everyone at the commission. So we just want to say thank you.
Here, thank you. Yes.
And so
With you.
that's all we want to say. And again, feedback is welcome. So please reach out if you have comments or questions, and we'll be sure to boost this on our website.
Excellent. Thank you. Ms. Vo, do we have any public comment? Okay, then it is 12:17. We're going to take a 45-minute recess. It's 12:18 now. We're going to take a 45-minute recess. So we will return at 1:03, 1:05. I know. We're going to return at 1:05. Good afternoon. It is 1:09 p.m. We are back from recess. We are going to be taking up item 14 again, adoption of proposed amendments to regulation 18341.4, probable cause proceedings. I'm not sure how much discussion there will be at this point, but just in case, Mr. Fazer, could you come up to the table, please? Okay. I'll keep that in mind. Good afternoon. I'm going to recognize Commissioner Brandt.
Thank you, Mr. Chairman. So I'm going to make a motion. I'd request a second. I'm happy to expand it. The way I've written this motion is it identifies the things that I want to hear from others, from the CPAA and from other interested parties. So I'll try this motion. I move that the commission direct the Law and Policy Committee to convene a hearing on the issues highlighted in our discussion about item 14. As part of that hearing, the commission requests that the California Political Attorneys Association and other interested parties provide evidence and arguments regarding how eliminating record production from the PC process, the political cause process, would deny a respondent's due process rights, or B, facilitate, or how it would facilitate or discourage settlement of case, and C, promote fairness in our process. Okay. So then I would invite, if there are other things you'd like to hear from people or those kinds of things, you talked, Mr. Chairman, about evidence that's not available. So
sure, I would further note that we're looking for evidence that underlies objections to inclusion of witnesses, as well as the other aspects of the amendments that we considered here today. And I not only want that evidence, or I wouldn't only suggest that we get that evidence from the regulated community and good government groups. I'd like us to take a look at whatever internal data that we have that speaks to the assertions that we make in the memo, so that we can make a decision based on that data. And if we're ever challenged in terms of whether we're acting appropriately, we can point to the specific data. I think a couple of those data sets that we talked about were witnesses, in terms of whether the witnesses testified to the actual violation at issue, or if they testified, for example, which has been my experience, as character witnesses for the individual, which I don't believe is relevant. I think that's important. I think in terms of data in determining, or at least considering, the facilitation, discourage of settlement, I think it would be helpful for us to see the average time of resolution after PCs where you have document production provided versus those that you do not. And I'm also open to whatever other data that legal division feels would strengthen or bolster their arguments. So again, so we can point to the public as to why we're doing this. I want to be clear. I don't know how this is going to affect the timeline. I do not want the enforcement staff to be coming up with this information. We can either as a commission or internally discuss how we can get this data without doing that. We're going to an election year. I'd really prefer that this not be something that weighs enforcement down. So perhaps this would be a project for our eminently qualified fellow who's smiling at me right now. But that's something that we can figure out. Again, also, like I mentioned, as well as Commissioner Brandt and several other commissioners, I'm interested in hearing what other agencies do, right? And then how those procedures are viewed, right? I'm interested in what the FEC does, and what I suspect we're going to see are criticisms of their protocol, because that's just generally what I've seen in my research and review of the FEC is there's issues in their enforcement process. So I'm interested in what they do under similar circumstances, and whether there's any data, criticism, opinion as to whether that is a good protocol procedure or an ineffective protocol procedure. I also think it would be interesting to see, because we speak to potentially gaming these rules, on how many circumstances, to the extent we can share this information publicly, has a request for document production or a request to delay a hearing resulted in a case being resolved and ultimately the facts of that case being disclosed to the public after an election. I think that's really a critical piece of this, and I think it's particularly persuasive and something that we'll want to lean on as we go forward. So I know
Okay,
it's
so I'd propose, if my seconder will accept, I'd propose some amendments to it to cover that. I mean, you did more than I'm going to have in the motion, and I think staff can do that. But so the motion would be.
Sorry to interrupt you, Commissioner Brandt. Executive Director West has one
yes.
clarification.
I would just ask that the motion not include the personnel assignments and you leave that.
Oh,
to-
yeah.
So that I
Right,
would.
that,
yeah.
for instance,
Thank you.
that's the way I'm gonna, leave it. I'm not gonna do that. I'm just gonna identify the issues that we wanna have addressed by, so we moved, that this hearing, I forget exactly what I said, but this hearing, that as part of this hearing, the commission requests that commission staff, CPAA, and any other interested parties provide evidence and arguments regarding how eliminating record production or hearing witnesses from the probable cause process would affect respondents' due process rights, B, facilitate or discourage resolution of the case, affect fairness, I'm welcome to on that, and staff, regarding staff legal arguments on these changes, so that's broader, or E, what other how other ethics agencies address probable cause. So those are the 5 things that we're touching on, and then you guys figure out how to do that. But basically, I just say commission staff, CPAA, and other interested parties. We invite them to do that. Okay, so that's my motion. Okay, so you're good with that.
Go ahead. Go ahead.
This is James Carson from CPAA. I just want to thank the Commission for the robust discussion today, and we look forward to continuing the conversation at Law and Policy.
Did I get everything that you think we should be making sure we invite you to address?
Yes, and we'll be happy to address it. Thank you.
Thank you.
Thank you. So we had a second?
Yeah, did.
Okay, Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Chair Silver,
Aye.
motion passes.
Okay. Thank you, Mr. Fazer. So now we're going to move on to, and thank you, Commissioner Brandt. Let's move on to item number 16, and that is the Form 700 search. We're going to invite our Communications Director, Sherry Yang, up for this item right here. Oh, and our Director of Admin, Ju Wang, as well. My apologies, Ms. Wang. I don't think you're listed here. But we're excited to have you.
Good afternoon, Commissioners. Good afternoon, Chair. Thank you for having us here today. We're really excited to present the Public Official Financial Disclosure Portal. Just for background, we launched this last week. We also held a press briefing with about 20 RSVPs from press. We received a lot of really good feedback from Cal Matters, who thanked us for the great product that we launched last week. So I have Ju here. She's going to be helping me with the demonstration portion. This portal was previously referred to as the Form 700 search. Our team came together and agreed to rebrand this portal to focus more on being data-driven. What we know is that the public doesn't want to download a form and review the whole thing to find, to find what they're looking for. They want to be able to put in a search term and receive the information they're seeking quickly in an easy to understand way. And that's what this new portal does. So first, I want to thank Granicus, who led this project in creating the features, and Ju here, who led the entire project that we get to now talk about. First, I'm going to just go over what the Form 700 is. It's the financial disclosure document where elected officials and other public officials with decision-making authority disclose their economic interests. These interests include investments in businesses and real property, business positions and sources of income, gifts and travel payments. And if you're interested in learning more about the Form 700 and who files them and what must be disclosed, you can find all of this information on our website under the Learn tab with our educational materials. So this portal allows users to review and download the Form 700 filed by public officials, and for the first time ever, search the data disclosed in those filings themselves. So let's start out with how to find and download a public official's Form 700. So similar to our previous portals, users can search for a public official's filing by agency or organization. So the agency field uses an autocomplete feature, meaning once you type 2 characters, the system will begin suggesting matching agencies. So for example, if you type Fresno, the system will return agencies that include Fresno in their name. And if you type county of, the system will return county agencies across the state. You can also search by position. So this field also uses an autocomplete function, making it easier to locate the specific offices. Another option is searching by filer name. And this system allows you to search using a first name, last name, or both. You can choose between exact match, starts with, partial match. This is also an option to show only currently held positions, which limits results to officials who are actively serving. So lastly, a quick note on the WHO's Form 700s you access in via the portal. The portal includes Form 700s required to be filed with the Commission on or after January 1st, 2025 by officials subject to Section 87200. So this includes the filing submitted by the following officials. You have elected state officers, including the constitutional officers and legislators, judges and commissioners of courts of the judicial branch of government, members of the Public Utilities Commission, the State Energy Resources Conservation and Development Commission, FPPC, the California Coastal Commission, the High-Speed Rail Authority, Planning Commissions, and Board of Supervisors. You have district attorneys, county councils, county treasurers, and chief administrative officers of counties, mayors, city managers, city attorneys, city treasurers, chief administrative officers, and members of the city councils, and so forth. The following Form 700s may also be found on the portal, including filings submitted by the Groundwater Sustainability Agency officials, historical filings from elected officials within the previous 7 years, and historical filings from statewide elected officials and FEPC commissioners dating back to 2012. And if you're unable to locate a specific form, please email form700@fppc.ca.gov for a copy. Now let's talk about how to search the data disclosed by public officials. So for the first time ever, you can now search the data within the Form 700 filings themselves rather than searching for a form. So for example, users can now search for keywords that appear directly inside disclosed forms. That means the portal can identify specific financial interests reported by a single public official or multiple public officials, including investments in businesses and real property, business positions, sources of income, gifts, and travel disclosures. So for example, a reporter can search for companies such as Tesla or Ford, and the system will identify filings that mention those forms. The system supports 3 types of keyword searches: exact phrases, all words, which is this finds results where all words appear within the same disclosure section, any words, which is where the results where any of the keywords appear within the disclosure schedules. User can also filter their searches by type of financial interest by selecting the relevant schedule. So for example, a reporter could search for Tesla within Schedule C, specifically the Form 700 schedule where officials disclose sources of incomes to identify whether Tesla was disclosed as a form of income to any officials in our database. So multiple search filters can also be used together to narrow results. For example, combining keywords with filing types or agencies. So next is the portal also allows you users to search for sources of gifts and travel payments, which appears on Schedule D and E. You can search by the name of the gift source and filter results by value range. So for example, a search could be conducted by gifts for gifts from a particular organization and filter to show gifts within a certain dollar range. So a quick disclaimer in regards to gift information: the receipt of gifts by public officials is regulated in 3 ways. There's reporting requirements, limits, and potential disqualification or conflict of interest. However, there are many exceptions to these requirements and restrictions, which are all provided in the state gift fact sheet that you can find on the educational portal or educational library. And I know this for you because you may come across a gift or travel payment in our database that at first glance appears to potentially violate the annual gift limit, but actually is exempt from the limits under the law. So for example, you might see a wedding gift from a non-lobbyist that exceeds the limit on Schedule D that is exempt from the limit or travel in excess of the limit on Schedule C that is exempt from the limit under the travel of the public purpose exception.
Just to clarify, so Schedule E is in Edward, not C is in cat.
Yes, yeah, Schedule
Yeah, no
E.
problem.
So while our goal is to keep officials accountable, we don't want the public to mislead us to whether they violated the law. So once a search is performed, the system will display the total number of matching results. And the most recent filings appear first. So I'm just waiting for you to.
Yeah, I think you just need to clear. I would just, before you do a new search, clear. There you go.
And then each result appears as a filing card, which highlights the sections of the filing that match the search terms used. Users can then download the full PDF version of the filing directly from the portal. So for electronic filings, the system will also display the specific sections of the form where the matching data appears. So for paper filings, the system will display the filing information and allow users to download the PDF. And finally, the portal has been designed to work across devices. So it is mobile friendly and responsive, meaning it can be accessed easily from phone, tablets, and desktop computers. And our goal with this system is to give the public more powerful tool to search for financial disclosures. So thank you. And let me know if you have any questions.
Excellent. Thank you for walking us through that. I thought, Commissioner Brandt, did you raise your hand? No. I would just take the opportunity to thank staff again for pursuing this, in particular the administrative division and their director, Dr. Wang. It's just an incredibly impressive tool that you all put together here. When we presented to the press, the example I gave was if you had a member of the press who wanted to see all the board of supervisors for every county in the state of California who owns stock in Microsoft in 2025, or I should say disclosed an interest in Microsoft in 2025. they would have had to download every single one of those forms for every single county in the state of California and review each one of those, right? And because, newspapers hold themselves to the standards that they do, they likely would have conducted that review twice at least. Now they can just put the name of the company in, and you have it right there. You have all this information. Of course, I would include the same caveats that our communication director mentioned. There's quite a few exceptions when you're dealing in the world of financial interests, especially gifts. And the last thing we want to do is create the appearance that public officials who are acting within the law are not. The last thing we need is a further dip in public trust. So I would hope anybody who's using the system strongly considers that and uses this tool in conjunction with our new website. So if you think there's an over the limit gift, guess what? Put gift limit into our search bar, narrow it down, filter your search down to fact sheets, and you're going to have the gift fact sheet. You can review that and take a look. And of course, if you see any sort of violations, we encourage you to reach out to our enforcement division. Commissioner Wilson?
Just kind of a quick question. There, stuck. Administrative Chief Wang and Communications Director Yang, quick question in terms of just have you received any feedback from elected officials in general, not specific elected officials, but either local or state elected officials or their staff who've kind of looked at the site, and given that more information is accessible, I was just curious.
I personally haven't. I've only gotten feedback from press, but you.
No, we didn't get any feedback from the elected officials.
Because somebody could argue, oh, now it's easier to get information about an elected official. Well, that was the case when the internet was introduced and people didn't have to go through binders. So, I commend you and, your team for this proactive approach. And I think it was very, very smart on your part to unveil it to the press first, because that way they're hearing about it from the source as opposed to stumbling onto the information on the website. So thank you.
Executive Director West, I think you can speak to that.
Sure. Good afternoon. Yes, I've heard a little feedback from the members of the state legislature concerned with any errors they may have made on their SEIs and reporting some interests that maybe they shouldn't have. So we provided a process in a form for them to expedite that, getting it remediated to reflect only what they needed to disclose.
Thank you.
And the reason why we were able to resolve that issue so quickly is with all of our technology launches, I feel like we've been very collaborative with the regulated community, the people who use these tools. So they know how to use it, they know how to use it correctly, and they know what to expect, right? So we let the folks, we let the legislature know that this tool was coming out so that they could research whether there were specific types of redactions that would be appropriate. So for instance, if you search Sacramento, their personal addresses that can be redacted do not appear in the on the website, because we absolutely acknowledge the potential security and privacy concerns there. So I'm really glad that we took that approach just then, rather than what Commissioner Wilson mentioned, just throwing this out there and waiting for a reporter to come and find all this information. Well, thank you again. You guys did an excellent job. Do we have any other questions from commissioners? Do we have any public comment on this item? We do not. Okay. Well, thank you again. Why don't we move to item 17, and that's going to be our generative AI acceptable use policy. We're going to welcome back to the table our Chief Information Officer. Nice try trying to do some other work, Mr. Hidalgo. Jesse Hidalgo, as well as our Executive Director, Galena West. Good afternoon.
Good afternoon. Keep it short and sweet. So this policy governs the staff use of generative AI. Executive order issued in 2023, the governor directed state agencies and departments to consider procurement opportunities where generative AI could improve the efficiency, effectiveness, accessibility, and equity of government. Since that time, the commission has been exploring how to build internal capacity to effectively, transparently, and responsibly use generative AI tools and generative-based software. The commission's generative AI acceptable use policy provides the guardrails and the expectations as we keep these in mind to consider using generative AI as we improve the commission's performance of its duties. Generative AI, for those, generative artificial intelligence, is a branch of AI technology that interacts with the user-provided creativity at the request of the user. And the FPPC recognizes that we can introduce generative AI into our agency with boundaries and safeguards to ensure its proper use. We also recognize there's risks, including unauthorized data sharing, bias, over-reliance, and disclosure of confidential information when using generative AI. This use policy will recognize those risks and provide restrictions and guidelines to ensure transparency and taking a judicious approach to implementation. I'll highlight the big major points for you. The first one is human in the loop. So basically this says that employees using generative AI, it's still your work product, you're responsible for it, and you have a requirement to always review any outputs and take responsibility for those outputs as you use them. Information, anything that we put in, any of the inputs, could be subject to Public Records Act requests. So those are all disclosable. So we want employees to know that up front. Microsoft Copilot is our available and approved vendor, and it's our most secure option right now for generative AI tasks. And we have employees can volunteer to use this program with approved training and supervision, and other programs are available with pre-approval. The FPPC requires disclosure to your supervisor when you're using generative AI for your work product. And then the state and the FPPC require a disclaimer anytime generative AI is used on your work that goes out to the public. The FPPC will provide ongoing training and work groups to train staff regarding the use, how to improve any generative AI that you're using. And we're putting out a survey. Hopefully, if this policy gets adopted today, then we'll be putting out a survey asking people their experience with generative AI, their interests, judging who would be interested in being an early adopter, and also trying to figure out where the staff is on taking their temperature a little bit on how excited or not excited they are about implementing this. So we'll be taking the next steps. We will also be doing an all-staff meeting and that we will discuss this policy with the staff, answer any questions, and we'll have some FAQs that will answer some just common questions that we came up with as we put this policy together. And Jesse's here to answer anything and everything else because as any of you that know me know that I am no technology experts. I'm all policy. Thank you.
All right, Commissioner Brand.
So I am at the National Judicial College, which is my, my daily data, my real work, or not anyway, it's my employer. I am leading this AI initiative that we have for courts use of AI. And we have our first webinar coming up in April. And so I want to ask you for your judgment about the things that are in this. So I've seen the policy, the things that are in this that address the risks. I appreciate you've identified a lot of the risks and those kinds of things. I want to hear your judgment about the 3 or 4 things that you think are most important to minimize the risk that it does any of the things that you've identified that are a problem.
Yeah, I think several things that have been put into our policy have been informed by quite a few standard organizations as well as Department of Technology. Human in the loop is a big one. Human in the loop allows us to mitigate any issues with outputs that might not be, that truthful or, what we call hallucinations. And it allows us to have human oversight, basically. So that's a big one. It's also recommended by Department of Technology, recommended by National Institute of Standards. Also, the approval from management to use for specific tasks. This would allow us to be more aware and have just more eyes on possible outputs that might be exposed to the public. Using enterprise level software allows for all our prompts to be kept in-house, sort of, so that they're not, any of our prompts aren't being used to train the LLMs that are behind our inputs. So those would be probably the three biggest things in terms of security. But all of our software is approved, and all of our applications that we use that are based that are using Gen AI are also approved through the Department of Technology. So if we do have a new program that we'd like to start implementing, we go through all of the standards set forth by the state, which includes an interview with the security team to evaluate the application being used.
Okay, so then the next question more specifically is, there are some courts that are concerned about judges using AI because it will undermine our public confidence. That, well, if we can just, why do we need judges if we can just, have AI make that judgment? And so we are doing things about training on what you can and can't do, and what kind of things to address that. So I want to hear from you, and maybe it's from Chief Brownbrake, about on enforcement. What are the protections to say we're still really making judgments? I mean, in other words, all the steps we did today, you're making judgments about enforcement, all those kinds of things. Are we going to start seeing that, we've done AI searches on, well, you compare it to other enforcement cases, and that may be a rape, but are there ways that we are publicly saying we're still making human judgments here? Because part of it is we're relying on you to make judgments for us to make judgments and make decisions ultimately. And so I want to hear from staff, whoever that would be, about use of AI and what are the protections to ensure that we're still relying on your human judgment and not AI.
Good questions. It's everything that Mr. Hidalgo had said as well, but it's also that we are keeping tight approval processes. So you have to have a use case that you're proposing that you're using this generative AI for. And if you're using it for work product, you have to disclose that to your supervisor. So we're trying to, in both parts of those, making sure that you have to have pre-approval and making sure that you're identifying to your supervisor, making sure that we are aware of when anyone is using it in their work and it's already been approved that they could. None of those uses that you're talking about are approved right now. So we're doing baby steps into this to make sure that each baby step we take is very regulated by the IT department and the executive office to make sure that we understand exactly how staff is using it and controlling the rollout. And as we move forward, say we wanted to have a program where comparable cases are searched to give you suggestions, that's what they would be. They would be suggestions of the cases that are most like your fact patterns, and that the attorney would then evaluate that 5 or 6 to determine the 2 that they would think about using and find out. And in the beginning, you have to also test the accuracy. So you have to do the real search yourself and make sure what you would come up with comes up with in those suggestions from AI. So it's quite the steep road to climb in the beginning. But the reason you climb it slowly is because you're doing the research yourself to make sure that it's the research that it would give you in order for it to even be trusted and implemented in the future.
Okay, thank you. That's helpful.
Yeah, I think it's worth noting that we've developed this policy. We've developed our approach to integrating generative AI into the FPPC workflows, albeit at a basic level, in conjunction with Department of Technology, in conjunction with GovOps, in conjunction with best practices, that were published by California state agencies as well as agencies outside of California. While we may be a trailblazer in terms of ethics agencies and the use of AI, we're certainly not a trailblazer in terms of the use of Gen AI in the government context. And we're lucky that that's the case because others who've come before us have been able to flag potential issues with rollouts that we're able to capitalize on because now we know to avoid those sorts of situations. Like the way that we handle document permissions, for example, is going to make it far less likely that any sort of sensitive information, confidential information is disclosed internally to someone who doesn't have access to it, let alone somebody outside. So I would say, to the question that you directed to Mr. Hidalgo, I think what we're doing is first we're using an enterprise tool and we're telling staff that they can only use this tool or another tool we approve. So the reason why using an enterprise tool is so crucial is because enterprise tools, they don't share the data that you share with them, with the company, right? That's in contrast to a personal ChatGPT account or other Gen AI account that you may have. Every one of those things that you're uploading into that profile, that company is most likely, I can't say for sure, taking all that information and training their models on that. So it's possible that if you share information with it, it might come up in somebody else's response provided by the model. That's unacceptable for us, right? So that's number one. Number two, we have human in the loop, right? So if, let's say we do create something that allows for staff to say, I want to see all the different conflict of interest resolutions in the past 10 years to see which one's closest to my fact pattern here. If a case is identified with a summary by the AI model, which we have not done yet, and I don't know if that's even possible, but if it is, and a staff member copied and pasted that into a STIP and submitted it to the commission, we found out that that was completely incorrect. That's completely unacceptable, and they'd be subject to discipline, just like they would if they made up anything in a memo. So what this is it's not meant to replace staff. This is just an efficiency booster, and it's an efficiency booster for staff who are interested in using it. If you don't think it's a value add, that's up to you. We're looking for staff who are interested in using these tools so that they can automate more redundant, boring tasks of the job and really focus on the aspects of your work that require your judgment, your knowledge, all those things. So we got enterprise, we got human in the loop, and the last thing is training. So folks have to take training before they use these tools. And that's not only because we don't want them to release some confidential information or do something incorrect. These tools are incredibly powerful, but only if you know how to use them. So we don't want to waste people's time. If they're going to sign up to do this program, we're going to make sure they understand how to use the tool and they're able to evaluate it, and then they're going to provide us with feedback. They're going to tell us, hey, this really helped me. This use case was excellent. I found that this use case where it summarized emails was not as good. That's the sort of information that we can share with the rest of the agency afterwards and kind of selling them on how this particular tool can assist them. We're a small agency. We have the entire state of California. I think this is going to make a big difference for us. But if it doesn't, that's just, we're very open to pivoting. So right now we're at the very early stages. We're doing a pilot program, which I'm very excited about, and I'm looking forward to working with staff and hearing from them specifically what they want to use this for, what they're comfortable with, and address their concerns. So, Commissioner Ortiz?
For Ms. West, so the human loop. So who's going to be that human? The supervisor for the little group? How are you going to do that?
So human in the loop is just in reference to the employee. So if you're the one that's using the product to help you with your work, you're going to also get the citations, ideally. It's your responsibility to read where the AI came up with that answer and make sure that you agree with it if you're putting the work product out. So you're the human and the loop is the AI helping you.
Okay, so I thought you mentioned something about supervisors
Sure.
reviewing what I've done.
So you have to identify, so you've used AI in your work product, at generative AI, and I'm your supervisor, I'm not, I'm just saying, but I'm
No, no,
saying,
yeah.
then you would have to tell me that you used Copilot to come up with this answer. And then that way I'm put on notice that you're using that in your work product. And then if I want to double check your answer or ask you for the prompts that you did, then I can see how you got to where you got and make sure that I agree with it.
So you have another level of,
Right.
not just me, but you also, my supervisor, who's
Mhm.
gonna look at it. Okay.
And then under certain circumstances, we're gonna have to disclose in the work product that we use generative AI. And that allows us, because we're gonna be conducting tests in terms of accuracy, bias, right? But that also flags it for the public so they can double check our work and make sure that they don't see any inaccuracy or bias. So we're kind of going above and beyond generally what folks do. And the reason for that is we want to make sure that we're doing this right and that the public feels comfortable, that we're not, doing what Commissioner Brandt laid out, that we're deferring to, a robot, which we're absolutely not doing here. Yeah, Commissioner Wilson.
First of all, Chief Doggo, great job, heading this up. And one of the things I was looking for, which I found in one of the footnotes, the background material, is that you're working closely with the Department of Technology, which I think is very smart on your part and the executive leadership team's part. But what happens if, and it wouldn't apply to FPPC, but it might apply to different agency, for example. What happens if a supervisor is using AI? Where's the check on the supervisor potentially? I mean, if you decide, you know what, I'm going to use AI for this, I know in your case, you'd probably have someone look at it. But what would happen, let's say in a hypothetical environment or situation where, you decide, oh, you know what, I'm going to use AI to write this proposal. Where's the check in that situation?
Yeah, I would say as an administrator of the system, I have the ability to audit the prompts of the system. So really that's the ultimate check on basically all data is IT is able to audit it. That a lot of that is based on just because it could be requested, prompts could be requested. So we do have to have that in place already. But just in general, we do want to know who's actively using the Gen AI in their daily tasks, if for anything, just to find out if it's working for them, or to see how it's being used. This is new technology for everybody, but it's going to be new technology for our commission, and we want to see. If it's working for somebody, then it would probably help multiple people. So especially in the beginning, we're going to be all sort of taking an effort and taking, putting a lot of eyes on this to see maybe we can make everybody just life a little bit easier, implementing, certain things into everybody's workflow. But it's going to take a lot of curiosity in the beginning to get us there. So I would say, to answer your question directly, we're all going to sort of be keeping an eye on the system in the beginning.
Commissioner Brandt?
Thank you. I'm just going to close by saying thank you. So there is an entity, I'll just call it an entity, that has requested us to do training on AI to help certain of their people draft decisions. And their response was, we've heard enough about hallucinations. And so we are going to do that training. We are going to do the kinds of deals that, they did acknowledge, let's hear a little bit about the risks, but the management is driving that decision for their people. And so I appreciate the management leading on being cautious, because I think that's going to ultimately be it. Because if it becomes a part of the culture that you're expected to do AI, because we don't have time for you to spend time doing research, or whatever that may be, I just think it is so important. And so I appreciate, all of you to being cautious and being careful. And that may change at some point, but for the next year or two, I hope we'll hear more about this and how it's going in 6 months.
Yeah, I agree. I think the state of California has really taken a look at Gen AI appropriately. I attend a lot of the Gen AI meetings with the state, and it's been a cautious progression throughout the entire process. So we got an executive order pretty early on to take a look at it, but I think it's because the landscape just showed that this is going to be impactful for everybody, and for us to take an aggressive but cautious approach is, we've sort of taken that on here, but also at the state level.
Excellent. Do we have any public comment? Okay, then I'm going to move to approve the FPPC Gen AI usage policy. Do I have a second?
Second.
Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Oh, yes.
Commissioner Ortiz? Aye.
Yes.
Okay, Commissioner Wilson,
Aye.
Chair Silver.
Aye.
Motion passes.
Thank you. And thank you, Mr. Hidalgo. Thank you, Executive Director West. General Counsel Bainbridge and your team for putting this together. Excellent job on this. Okay, let's move on to our legislative update. We're going to welcome up to the table Senior FPPC Legislative Counsel, Lindsay Nakano. Good afternoon, Ms. Nakano.
Good afternoon, Mr. Chair and Commissioners.
So what sort of faces do you see when you tell folks that we have 10 sponsored bills?
I'm about to find out.
I've seen some funny faces.
Yes, it's a busy year. There are currently 17 active PRA bills, including 10 of our sponsored bills, as you said. I'll go over the details of all of them today. A couple of them are still in spot bill form, and they will be amended shortly with the substantive language, but I will go into what they will eventually include. A quick update on committee hearings. The first Elections Committee hearings have been set. The Assembly Elections Committee will meet next week on the 25th, and they will hear 4 PRA bills, including 2 sponsored bills, as well as some other elections code bills. And the Senate Elections Committee will meet on April 7th. They will hear 1 PRA bill, which is not one of our commission-sponsored bills. Before I go into bill details, I wanted to flag that the authors of 2 bills that are not commission-sponsored have requested FPPC support. Those are AB 2413 by Assemblymember Ransom relating to large format public advertisements paid for with public money, and SB 1175 by Assemblymember Rubio, which streamlines the filing process for lobbyist registrations and terminations. And I'll go over the details of both of those bills later in the presentation, and we'll bring them up for potential commission support after any questions or discussion. I'll move on to the bill summaries for commission-sponsored bills, and I will go over everything. AB 775 is a 2-year bill. It was first introduced last year. It's currently in the Senate Appropriations Committee and will be brought back up later this year. The bill would require behested payment reports submitted by elected state or local officers and members of the Public Utilities Commission to be electronically filed directly with the Commission. As an alternative to electronic filing with the FPPC, the bill would permit local elected officers to file directly with their local filing officers under the condition that the reports are publicly posted on the local agency's website. The bill would move to a quarterly filing deadline. It would creating a regular schedule for these reports. It would also provide a threshold for when a subsequent report must be filed for any additional behested payments from the same donor after an initial report was filed for that donor, and would codify 2 existing regulations. Moving on to AB 1736 by Assemblymember Pellerin. This bill would extend an existing prohibition that applies to lobbyists and lobbying firms to additionally apply to lobbyist employers. The bill would extend that prohibition such that lobbyist employers would be prohibited from creating a fictitious appearance of public favor or disfavor of any proposed legislative or administrative action, or sending a communication to certain public officials in the name of any fictitious person or real person without their consent. The practice of creating a false appearance of public support is sometimes referred to as astroturfing. This is one of the bills that will be heard next week in the Assembly Elections Committee, and Chair Silver and I will be in attendance in support. AB 1788 by Assemblymember Berner relates to the disclosure requirement for nonprofit organizations that pay for elected official travel where one or more donors accompanies the official on that travel. Existing law requires a nonprofit organization that made travel payments for elected officials to disclose the names of donors to the nonprofit organization who donated at least $1,000 and accompanied the official on that travel in the preceding year, if certain travel spending thresholds are met. Specifically, existing law requires reporting if the nonprofit organization made travel-related payments greater than 1/3 of its total expenses, as reported on the organization's Internal Revenue Service Form 990, and that made payments, advances, or reimburses for elected official travel that total more than $10,000 per year or $5,000 per year for a single official. The bill eliminates the 1/3 threshold, which was determined to be ineffective by FPPC staff, and instead requires reporting if the nonprofit makes expenditures for travel for elected officials of $10,000 or more, or $5,000 or more per year for a single elected official, consistent with those existing monetary thresholds. The bill also adds to what must be disclosed on these reports by requiring disclosure of each travel expenditure and the name of the official for whom the expenditure was made, as well as adding standard record-keeping requirements. This is the second bill that will be heard next week in the Assembly Elections Committee. AB 1789, also by Assemblymember Berner, is currently a spot bill, but it will be amended shortly to include the Commission's proposal to require that candidates and treasurers of candidate-controlled committees take a mandatory training course on the campaign requirements in the PRA. A candidate who fails to take the training would not be subject to typical enforcement under the Act. Rather, a candidate who fails to complete the training would not have their name printed on the ballot. If a treasurer fails to complete the training within 30 days from being identified as treasurer on the committee registration, the committee would be prohibited from accepting any new contributions until the training is complete. Treasurers would also be subject to, or potentially subject to, an enforcement action under the Commission's General Enforcement Authority. These compliance mechanisms are designed to help ensure that candidates and treasurers receive this training as early as reasonably possible, as many of the important duties under the Act quickly become due upon becoming a candidate or registering as a committee. AB 2255 by Assemblymember Pellerin would help shed more light on large expenditures made during periods when the candidate will not be on the ballot in the next election. Under the bill, for each aggregate expenditure to a single person over the threshold amount, the committee would be required to disclose a description of any consideration for which each expenditure is made, and if applicable, the relationship of the person or reportable sub-vendor to the candidate or any individual with authority to approve the expenditure. And please feel free to stop me if you do have questions in between. Otherwise, I'll pause at the end for questions or comments. AB 2421 by Assemblymember Valencia was a spot bill and was amended this past Monday to add the substantive proposal. The bill would require the Secretary of State's office to terminate inactive campaign committees that have not themselves terminated under specific conditions. A committee could be terminated if they have not submitted campaign reports in at least the last 12 months and had a cash balance of under $3,000 on their last campaign statement. A committee could also be terminated if SOS determines that the committee registered as a committee in error. FPPC staff meet weekly with SOS staff in their political reform division, and this issue was brought to FPPC staff's attention during these meetings. Thousands of actually inactive committees appear in CalAccess as active, making it challenging and inefficient for the public and others to sort or search through all of these committees and find relevant information on current campaign activity. With the CalAccess replacement system on the horizon, this bill would help ensure that these inactive committees do not stay in the new system. AB 2592 by Assemblymember Pacheco. This one is still a spot bill, but will be amended shortly with the Commission's proposal to transfer the lobbyist training from the Legislative Ethics Committees to the Commission. In addition to transferring the training to the Commission, the bill would require that this training is provided on demand for lobbyists through an online platform, web page, or application, which would create convenience for lobbyists, helping them come into compliance with their training requirements. Yes.
Commissioner Wilson?
I had a second to get that in. You're doing a great job in the summary, but on 2592, transfer of lobbying training to the FPPC,
Yes.
I'm assuming the answer is yes, that if this bill is passed, there will be sufficient funding to make sure that the FPPC gets the resources it needs to backfill any staff positions and so forth.
Yes, this bill includes a built-in fee. To the extent it doesn't cover the full costs of the training, we would include that, we would provide that information to the Appropriations Committee, whatever that might cost to the Commission, and that would continue to be part of the discussion as the bill moves forward.
Thank you.
And would we also receive existing fees that were accepted prior to us receiving the mandate to do the training?
We have a provision in the substantive language that would require any existing or remaining funds that are with the Legislative Ethics Committees for this training to be transferred for the Commission. So correct, yes.
Okay, excellent. Thank you, Ms. Nakona.
Mhm. Okay. I think I covered everything for that. Oh. Okay. It's okay.
We're going to go into recess and we'll be back at 2:10. Thank you. Okay, we are back from recess. It is 2:11. Ms. DeCano was just presenting to us on AB 2592. And I don't have any additional questions. Do any other commissioners have questions on AB 90 or 2592? I don't know if it's something we've already shared with the author and the legislature, but I am obviously absolutely open to coordinating with them and collaborating with them on the substance of the training. I know as someone who did the training in the past, there were aspects of it that did include some assembly floor policies as well as Senate floor policies. And I think that would be, it would be key and critical to include that in the training that we offer should this be switched over to us. So I look forward to working with them. And it's worth noting that the sponsor, I should say the author of this bill, is the chair of Assembly Rules. Okay, take it away, Ms. Nakano.
Thank you. Okay, I'll move on to the next bill, AB 2655. This is by Assemblymember Valencia. This bill amends the section that authorizes candidates and elected officials to spend campaign funds for security expenses. The bill would require that if campaign funds are spent on security personnel, that security personnel must be appropriately licensed by the Bureau of Security and Investigative Services. SB 401 by Senator Hurtado was presented at the January hearing, so I'll be brief. The bill would authorize the commission to extend filing deadlines in the PRA for individuals impacted by a state or local emergency. And last of the sponsored bills, SB 1389 by Senator Dawley, currently a spot bill, will be amended shortly to include the commission's proposal to expand the filing officer authority to waive the late fee for a late statement of economic interest when the late filing was not willful. Currently, filing officers have discretionary authority to waive the late fee within 30 days of the filing deadline. SB 1389 would instead provide that the filing officers have authority to waive the late fee within 30 days after the late filing has been referred to the commission. I'll pause here for any questions or comments on commission-sponsored bills before I turn to the other commission-related bills.
Go ahead.
Okay, seeing no questions, AB 1560 by Assemblymember Tanjipa was presented at the January hearing, so I'll also be brief. The bill would prohibit a person from acting as a lobbyist if the person has been convicted of a crime of public corruption as defined in the bill. AB 1840 by Assemblymember.
A couple
Yes.
questions. We'll let you go first, Commissioner Ortiz.
Good question.
Can you give some example of a public corruption?
Yes, it is. The bill references an existing elections code section, which I will pull up. Okay. It's section 20 of the elections code. Thank you for your patience.
Yeah, and it looks like I could just read off the report,
Yeah.
then Lindsay can clarify.
It's in my report.
Ms. Takano, I apologize, Ms. Takano.
No.
So it is defined as a crime of public corruption is defined as a felony involving accepting or giving or offering to give any bribe, the embezzlement of public money, extortion, or theft of public money, perjury, or conspiracy to commit any of these crimes. Is that correct?
Yes.
Okay, thank you.
And then who makes that? So I assume this is going to go, if this is in the PRA, it's going to be our job to prosecute folks who are in violation of this law generally, right?
Yes, if a lobbyist registered and did not, while knowing they were convicted of a crime of this type, they would be in violation of the act, yes.
Okay, and so would it be our duty to, and maybe this is something we want to talk to the author about, I don't know if we have this answer. So is it our duty to go look up lobbyists' criminal records? Or if we receive a complaint, we're going to have to figure out a way to look at criminal records? Do we have access to that sort of information?
I think we have, I'll have to look back at my notes from the enforcement division. We have some limited access to, conviction information. But I can be a little bit better prepared next commission hearing to discuss exactly what access the enforcement division has to that conviction history.
Thank you, Ms. Nakano. That just popped off the top of my head, so no reason for you to be prepared for that. Commissioner Wilson?
Interesting, some good, questions that have been posed, but I have an additional question. Would this bill, has anyone looked into, I'm assuming they have, if this bill is constitutional? Because if someone is convicted and they serve their time and they get hired as a lobbyist and they registered, why can't they continue to lobby? Now, they might have some challenges, but just a kind of a rhetorical question. You don't have to research it. I'm just curious.
I appreciate the question. I can at least raise the question with the Assembly Elections Committee consultants who typically considers matters of constitutionality.
Just don't tell them I asked, though.
Okay, seeing no further questions or comments, I'll move on to AB 1840 by Assemblymember Sanchez. This bill addresses a newer type of financial exchange that is novel for the Commission relating to something called prediction markets. This bill, AB 1840, would prohibit an elected or appointed public official, any individual required to file Form 700, or a lobbyist from knowingly engaging in the purchase, sale, or exchange of a prediction market contract. This is something that bets or speculates on the outcome, occurrence, or non-occurrence of an administrative action, election, governmental decision made in the course of the individual's official duties, or any legislative action or decision, if the individual possesses or it is reasonably foreseeable that the individual may obtain in the course of their official duties material non-public information relating to the purchase, sale, or exchange. And to generalize that, the bill prohibits anyone required to file Form 700 or a lobbyist from essentially placing bets relating to administrative or legislative actions or other government decisions if the individual has inside information. And again, this is a new area of regulation broadly and for the Commission. Staff are continuing to research this issue in order to make informed recommendations. AB 2413 by Assemblymember Ransom generally would prohibit public funds from being used for large format advertisements that feature the photograph of an elected official. The author has requested the Commission's support on this bill, and I will raise the issue for consideration at the end of any discussion. Adding more detail, the bill would prohibit a large format public advertisement from being published or displayed at the public expense if both the advertisement includes a photograph of the elected official and the ad was prepared in cooperation, consultation, coordination, or concert with the elected official, and the costs of distribution of the ad are paid with public money, or the costs of design, production, and printing are paid with public money, and the design, production, or printing is done with the intent of displaying the advertisement. Under the bill, a large format public advertisement includes a billboard, a wrap on a bus or other public transportation vehicle, advertisements affixed to a bus stop or other public infrastructure, or public advertisements that are larger than those designed to be individually distributed and that are specified in regulation by the Commission. The bill idea originated from ads spotted in the author's district. According to the author's office, the Assemblymember noticed billboards for the local air pollution control district that included photos of individual board members who were also elected officials. The bill was written to mirror relevant portions of the existing prohibition on mass mailings at the public expense, which is broader and more stringent than this particular bill. As a refresher, the existing prohibition on use of public funds for mass mailings prohibits using public funds for tangible items like mailers if the item features an elected official affiliated with the agency, or if the item includes the name, office, photograph, or other reference to the elected officer. And I'll pause here for any questions or discussion before the consideration of a vote on this bill.
I have one question, Ms. Nakano. So when we look at the definition of large format public advertisement, that's not an exhaustive list, correct?
Correct.
Just because I know it can be a difficult task for folks to navigate all the different disclaimer requirements from all sides, right? Whether that's here at the FPPC or in the regulated community. I want to make sure that there's a tight definition here and none of the stakeholders are confused as to what this is. I think what a large format public advertisement is, I think what's excellent about this bill and why I'm inclined to support it is that it allows us to avoid a lot of the litigation that we typically engage in regards to a misuse of public resources for a campaign purpose. We're pursuing a public entity that doesn't register as a committee or perhaps violates some of the reporting requirements, right? This is much more akin to mass mailing at the public expense, where we don't have to worry about unambiguously urging a particular result in the election. There's specific criteria. If you meet it, you violated the law. That's the sort of rules that I'm looking for. I think enforcement in particular is looking for, and I think the people of the state of California are looking for it too. So perhaps what makes sense before I go forward with this, I'd like to get your feedback on what the timing is here and whether us not sponsoring today, or I should say supporting today, could potentially significantly impact this bill. I'm interested in hearing from the regulated community, good government groups, including Clean Money Campaign, what they think is a easily interpretable, straightforward definition of what this is going to apply to.
And I'll add a little bit of clarification. The bill is non-exhaustive in the sense that the commission by regulation can specify other types of advertisements not listed that are included in that definition. So the list that is provided in the report and that I stated, billboard, wrap on a bus, or other public transportation vehicle, advertisements on a bus stop or other public infrastructure, it is exclusive to that unless or until the commission decides to expand that. So it would only apply to those generally 4 categories of advertisements unless there's a regulation that expands it to specific other types of ads.
Okay, and the 4th bullet point where it says other public advertisements that are larger than those designed to be individually distributed and that are specified by regulation, is there a specific, are there dimensions laid out in the statute? Does it say, if it's bigger than 30 inches by 40 inches, then it's gonna be subject to this. If it's smaller, it's not?
I think that language was pulled from another area of the PRA, which refers to advertisements larger than those designed to be individually distributed. I don't know if we have interpreted that to mean a particular dimension. In this context, it's something that we could specify in regulation. I can also seek further clarification from the author's office. But generally, their intent, as I understand it, for this provision was to give the commission authority to expand it if there are kinds of advertisements other than those listed that the commission believes are appropriate, that appropriately fit into the intent of this prohibition.
And that's an important clarification. I'm glad you clarified that. I support that, giving us discretion to add specific items, right? I just get concerned when there's open-ended language as to what is a large form public advertisement. So, Commissioner Ortiz?
Thank you. And I appreciate that as somebody who came from the AC Transit Agency that we wrapped buses. I appreciate your sensitivity to it. The key word here is if the wrapping or the sign is paid for by the public agency. If it's, let's say, an elected official to the agency wants to put an ad paid for by him or her with a disclaimer, then that's okay.
Yes, this does not affect typical campaign
So
advertisements.
this is just paid for by public agency.
Exactly, yes.
Thank you.
So, based on what you're hearing from us, Ms. Nakano, I generally, just myself, I support this policy. I want to make sure that the definition is tight and understandable and clear to the public. What action would you recommend that we take? Do we do a supportive amend? Do we tell them that we support this idea generally and that we want to engage with them further on this one piece and then wait until our next meeting to take a position?
Would you like to see something like specific dimensions, or language like dimensions similar to advertisements seen on a billboard or a bus wrap, or something that provides a little bit more specificity as to what it means to be larger than those designed to be individually distributed. I think that the author's office would be open to that kind of clarification. So we could, if that is the kind of sticking point, we could do support if amended to make that kind of clarification.
Yeah, I just want to make sure that they understand that we're supposed to, at least I'm supportive, I guess I'm putting the cart in front of the horse.
I'm fine.
Where other commissioners as to this policy here, this legislation?
No.
You're supportive?
Yeah, it's public money. I mean,
Yeah, supportive of in
Absolutely.
concept, yes.
Yeah, and preserving staff resources as well. Concerns about ambiguity and definition of what it
I
is?
do think that your issue about size is important to define what is it that we're talking about on the size, which in the turn, so let's say it's 5 by, I don't know numbers, 5 by 20, something. But if it is 2 by 1, is that that permissible, even though you use public money?
Yeah, that's a good question. I think because exactly what it means to be large format is not defined, as long as it fell into those categories of billboard, bus wrap, advertisement on a bus stop, or other public infrastructure, it would probably be pulled into this. But there would be some interpretation potentially from the commission on that.
Yeah, because for example, like the mass mailing sent to public expense provision, which is very similar to what we're looking at here. It limits it specifically to a tangible item such as a videotape, a record, or a button, or a written document. Well, I guess actually that's more of a, that's not an exhaustive list. It's just saying the only thing that's required is that it be tangible. So with that, my position is I'd like to support it. I just want to be confident that there's no sorts of technical issues that we're creating for ourselves and for the regulated community by going with the definition they have right now.
Mm-hmm.
So based on that, if I don't have specific dimensions for you, I don't know if it's going to be 30 by 20, what have you. What do you recommend that we do?
The author's office has been very open with wanting to work with the commission. I think they'd be very receptive to any feedback we had on clarifying the definition. So if the commission wishes, we could, you may vote to support with the understanding that the author's office would continue to work with us to clarify the definition.
Go ahead, Commissioner Wilson.
Yes, I, along with the chair and other commissioners, support the concept. But in the event of a violation under this bill, and I'm going to read the bill later today, what would be the potential penalty if someone says, well, I want to be on that side of that bus, and the agency is supportive of that, and I'm willing to deal with the consequences.
Risk
Yeah.
versus the benefit.
What are the potential repercussions?
The violation would be subject to the default penalties in the Political Reform Act, so a maximum of $5,000 per count. Yeah, per bus, as our general counsel says.
Per bus. That would be per bus, okay. Then that would be a deterrent.
Is there an interest in allowing for liability that extends to the cost of the advertisement? Right.
So if you're only going to pay $5,000 penalty versus the distribution of that.
And the agency would pay the fine, presumably.
As written, I think that would be a violation by the agency, yes.
Would it be
Right.
both?
I would just remind the commission, for those of you that have been here a while, these sort of misuse of public funds violate other laws.
True.
So this isn't the whole universe of what someone who misused public funds. I think this would establish that this is another area that is considered a misuse of public funds, which could create liability under other areas of law that are not our problem.
Excellent. That's an excellent point by our chief counsel, but I'm thinking of the situation where there have been the mass mailing prohibitions. And it's, in most cases, not in all, but in most cases, it's the governmental entity that's paying the fine. But the decision is being made by individual elected officials, in many cases at the local agency. So that's, if you're an elected official and you don't have to pay the fine, but that the governmental body pays it, there's less of a deterrent.
That's a good point.
Well, it sounds like we have a fair amount to discuss here.
Okay.
Is it going to be on the agenda for the upcoming elections committee in either house?
This one is not on the upcoming hearing. I imagine it will be heard next month. I don't know exactly what date. So I don't know at this point whether our next meeting will be before the hearing.
Do you think it would be helpful for the author if we had a law and policy meeting to consider this so that we can give them direction that they can share with the elections committee before their hearing? Or do you think it'd be better for see, Executive Director West suggested support if amended. I think that makes sense in terms of the one concern that we had with the dimensions. How about this? How about we move for support if amended as to the dimensions, and we provide additional feedback to the author's office separately in regards to potential remedies?
Although I think that Commissioner Wilson raised a very good point. If I'm an elected official, I'm going to take the chance because I know the public agency is going to pay for it. That's an important issue.
Yeah, I would remind the commission that we've also been finding liability for the individuals that aided and abetted and caused the violations.
Okay.
So the direction of the commission the last couple of years was for us also to look for the individual responsible in those public mailer cases. So that's the direction that enforcement has been taking.
Okay, so I'm going to move that we support, if amended, to address the dimensions specifically to make them clear to the public.
Second.
Do we have any public comment? Okay, Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Chair Silver.
Aye.
Motion passes.
Okay. Let's continue.
Okay, thank you. I'll move on to SB 1159 by Senator Cabaldon. This bill would provide that for the purposes of the Act and other specified areas of law, including the California Public Records Act, the terms person, interested person, participant, member of the public as applicable, and any similar terms referring to those who may engage with governmental agencies do not include artificial intelligence systems, autonomous agents, robots, or other non-human entities, whether physical or digital. The intent of this bill is to prevent automated mass engagement that can overwhelm government agencies and provide that laws giving the public rights to engage with government agencies apply to natural human beings and not AI or similar automated systems. We are seeking clarifying amendments to ensure that the bill doesn't have any inadvertent effects on the PRA, since the Act's definition of person does include business entities and committees and those types of entities.
Thank you.
Okay, moving on to SB 1175 by Senator Rubio. This is the second bill that the commission has been, the second and last bill the commission has been requested to support. The bill is sponsored by the Secretary of State's office and would enable lobbyists to file amended lobbyist certifications or notices of termination directly with the Secretary of State. Currently, if the lobbyist wants to file, or a lobbyist wants to file an amended lobbyist certification or wants to terminate as a lobbyist, they must file the amendment or termination paperwork with the lobbying firm or the lobbyist employer, and then the firm or employer must file that paperwork then with the SOS. According to the author's office, From their fact sheet, the current lobbyist registration system creates significant delays and transparency issues when lobbyists change employers or need to update their registration. Because a lobbyist can only be registered with one employer or firm at a time, lobbyists must wait weeks for their former employer to file termination paperwork before they can register with a new employer. During this waiting period, lobbyists cannot legally begin work with the new employer, and lobbyists' relationship with the new employer remains undisclosed to the public. In the CAR system, lobbyists must be properly registered with their current employer to submit required disclosure reports, meaning employer delays in processing terminations could result in lobbyists filing late disclosures through no fault of their own. Additionally, lobbyists cannot update routine registration information such as phone numbers or email addresses without their employer filing an amendment on their behalf. I'll pause here for any questions or discussion before asking for consideration of this bill.
Yeah, agreed. I think this is an excellent idea. I don't know if we have an answer to this question, but is there any explanation as to why there was this arrangement in the first place where lobbyists would file with their employer or their firm rather than filing with SOS directly?
It's a good question. I don't immediately have the history of this section. I can look into it, but I don't have an answer right now.
Okay.
Can I move? I want to move.
Okay, I think I hear a move.
I move that we support this bill.
Second. Ms. Vo.
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Chair Silver.
Aye.
Motion passes.
Thank you. Okay, SB 1125 by Senator Nilo would require the legislative analyst instead of the Attorney General to prepare the official summary of measures that will appear on the ballot, contingent on the passage of similar proposed changes in the California Constitution. This may sound familiar. There was a substantially similar bill in 2023, SB 858, and there have been several attempts in the past to make similar changes. The 2023 bill was held in the Senate Appropriations Committee.
Can I make a comment?
Of course, Commissioner Wilson, or Commissioner Ortiz.
I think, if I'm not mistaken, this proposal have been introduced for the last 13 years, I think. If I'm not mistaken, they've been trying to change this for 13 years.
Maybe even longer. I think the first bill was 2008. I was looking at the history today. Yeah. Okay. We're almost to the home finish. The last one's SB 1432. This is a committee bill authored by the Senate Elections Committee. At present, the bill includes only one relatively minor change. Under existing law, lobbyists and lobbying firms that send a written invitation to an elected state officer, candidate, or legislative or administrative official must include a statement on the invitation that states, "Attendance at this event by a public official will constitute acceptance of a reportable gift." The bill increases the required font size of that statement from 8 to 10 points. Additional proposals might be added to this bill in the future, and I'll keep the commission updated on any changes.
Excellent, thank you.
That concludes my presentation. Happy to take any questions.
Sure. Well, one thing I think we should do is just double check for public comment, of course, generally on this item, and then as to 1175, SB 1175. Do we see any public comment? Okay, excellent. Then we can move on to the next item. Thank you.
Thank you.
Ms. Nicano. Okay, let's move on to item number 19. It's our executive staff reports. We're going to welcome back to the table Chief Bonebreak. Good afternoon.
Good afternoon. Our report is as submitted, but I'm happy to answer any questions.
Do any commissioners have questions for the chief? I do not. Just again want to reiterate how impressed I am with the fact that we hit the numbers that we did this month. That was very impressive. Thank you.
Thank you all.
Okay, let's move on to our next report, and that's going to be audits with our Audits Division Director, Sharada Shah. Good afternoon.
Good afternoon. My report is as submitted. However, I do want to give a quick shout out to my audit team. They've worked really hard, and we adopted 6 audit reports in the first 2 months of this year. So I just wanted to say thank you for the hard work they've done.
Yeah, it's very impressive. This is a really stacked agenda. So you should be really proud, you and your staff.
Yes.
Thank you. Commissioners? No? Okay.
Thank you.
Thank you. For the record, Executive Director West is clapping.
6 audits.
Okay, let's move on to Legal Division, General Counsel Dave Bainbridge.
Yeah, just a couple of things to note. We have up now our fact sheet for the changes to the law that took place for 2026. We also have a website with that information. And then the new version of the act, the 2026 paper version of the act, is up on our website. We have a obligation to create that every year, so it's there. We had some people asking about it. It is now there. And then we have a couple of new prep courses that have, we now have graduates, so we don't mention them until we have people actually enrolled in them and passing them. We have a new course on independent expenditures and major donor committees. We had a couple people complete that one. And then we have one on advertising disclosure requirements, and we have one enrollee, so hopefully next month I'll be able to report a graduate in that course as well.
Excellent. For a moment there, I thought we were going to name each one of our graduates, maybe have them walk through.
I'm sure they'd love for us
I'm
to
sure
mention their name.
they would too.
Give a test.
Yeah.
I want to make a comment.
Yeah, Commissioner Ortiz.
Email requests for advice. It's quite impressive that out of the 719, 541 were responding within 24 hours. You know, those advice via email are so important. I used them before, so I know. Yeah, thank you.
Yeah, thank you for acknowledging that. It is pretty impressive number that they can get through the emails that quickly.
Thank you. Okay, moving on to Administration and Technology Division. Dr. Wang. Good afternoon.
Good afternoon, Chair and the Commissioner. My report as submitted, I just want to highlight as of today, for the March 2nd group, the non-filer number has reduced to 12, which include 11 from the court and 1 from Constitution Officer. So we already sent out the non-filer letter. Hopefully all those non-filer gonna be filed as soon as possible. So I just want to give shout out to the SEI unit, and we are done with our March 2nd group, and we're going to be ready for March 1st group.
Excellent. Or April 1st group.
April 1st group.
There you go. Okay. Well, thank you so much to you and your team. I know this is an incredibly busy time for all of you, and you all did an excellent job at this deadline. I hear nothing but great things about the SEI unit. So
thank you.
Yeah, thank you. For perhaps this makes more sense at not the April, but the May meeting, once we pass the April deadline, if we could get an idea of how we did in terms of timely filing versus past years. If we could present that data at that meeting or June meeting, if that's not enough time for you. Does that sound good? I think that'd be helpful.
Yeah, I think that's a good idea. We can do the comparison, how we can improve for next.
Excellent. And then it sounds like we have several employees to welcome. We have a new special investigator, Mr. Wolcombe, new attorney, Ms. Shands, a not so new staff services analyst who got promoted, Ms. Rader, congratulations. And then we had a new employee in the legal division, Maya Kirkham. So welcome to the FPPC. We're glad to have you. Thank you, Dr. Wang. And now we could move on to our next report, which is our Executive Director report, Galena West.
Hello again. So I would just like to reintroduce our Communications Director, Sherry Yang. She's going to give us a little summary of some outreach that was done. Sherry.
Hi, everyone again. So you may have the stakeholder report in front of you. I'll just briefly go over this report. So in 2025, the chair and I conducted a series of stakeholder outreach conversations with individuals who regularly interact with the FPPC. This included attorneys, lobbyists, campaign consultants, local agency representatives, legislative staff, advocacy organizations, and elected officials. The goal is to sit down with stakeholders and listen to their experience and better understand how they engage with the FPPC. I do want to note that this was a relatively small group. We had 14 participants total, so this is not intended to be a comprehensive set of findings. Rather, it serves as a starting point for continued dialogue with the regulated community. That said, the feedback was thoughtful and incredibly valuable. It gave us a clearer picture of how stakeholders experience our resources, our communications, and services. One of the most consistent takeaways was just how much stakeholders value the FPPC's professionalism, our credibility, and commitment to transparency. Our education and guidance work in particular came up repeatedly as one of the agency's strongest assets, which is a direct reflection of the FPP staff work today. A few key themes did emerge, and I'll walk through those briefly. The first was the website and digital navigation. Some stakeholders share that they've historically relied on Google to find FPPC resources and express interest in stronger search functionality and clearer navigation. This is an area where staff have already made significant progress. The recent launch website, as was talked about today, directly addresses these concerns with improved search capabilities, a more intuitive structure, and clearer audience-focused pages. At the same time, stakeholders consistently emphasize that the FPPC website is a critical and trusted resource because of the depth and quality of information it provides. The next was guidance and education. This was one of the most positive areas of feedback. Stakeholders strongly value our manuals, fact sheets, and training programs. They also express interest in expanded educational content. These are areas where staff have already been actively building. Chloe Hackert and her team continues to be a core strength for the FPPC, and that continues today through well-attended trainings, growing newsletter engagement, and ongoing efforts to incorporate real-world examples while maintaining clear and accurate guidance. And then third is enforcement and audits. Stakeholders describe enforcement staff as professional and emphasize the importance of enforcement and maintaining public trust. The feedback were focused on clarity, clear audit notifications, and better understanding the enforcement process. Again, this is work that is already underway. Staff is exploring more formalized audit notification processes in coordination with the Franchise Tax Board and our audit division. A communication style guide has been developed to promote clarity and consistency, and enforcement continues to refine intake process. And then fourth is communication and outreach. Stakeholders express strong appreciation for the agency's communication efforts, including the newsletters, social media, trainings, and inter-agency partnerships. So suggestions focus on expanding election cycle updates, provide more scenario-based reminders, and developing resources that can support offices experiencing staff turnover. So these efforts are already in motion. The FPPC newsletter continues to expand in both content and reach. Deadline reminders are integrated within all of our communication strategy, and staff are actively exploring ways to create more evergreen resources for our stakeholders. In addition to these broader themes, we also heard more specific feedback across stakeholder groups, from easier access to advice letters and enforcement decisions to simplified access to key forms like Form 700 to increase interest in digital tools and searchable data. And we talked about that today through our public official financial disclosure portal that we launched last week as well. So across all of these perspectives, the common thread was clear, which was that stakeholders recognize and value the FPPC's role in promoting transparency and supporting compliance. And that is all for today.
Commissioner Bray?
Thank you. I just can't believe how that a regulatory agency is getting this kind of feedback. So great. And I would invite anybody who is out there like, oh, that FPPC, we want to hear from you too. But yeah, but I'm thinking it's great. And I'm glad we're doing this engagement. And I think we learn things. And I think the other piece is the value of what you've done and what you showed us earlier on the website and all those kinds of things. So I think all those things together are, I'm very proud of you. So thank you to you and all the staff who've been part of this. But I have to admit, I was kind of surprised when I read this. It's like, okay, so are we really that good? I mean, I don't know, it is compliments to all those who make it happen, because not us. I mean, it's you guys who are out there dealing day to day with people. And I think that your professionalism and all those things that they highlighted is you deserve our thanks.
Agreed.
Good job, Galina.
I think it's tremendously important that we do get negative feedback as well, so that we could take action. And I also thought that this project that I got to do with you, Ms. Yang, is going to be tremendously helpful for the future, because now we're going to have a baseline that we could take a look next time we go and talk to stakeholders. Hey, do you feel like this has been addressed? Do you still have this concern? Do you still think we do this well? Yeah, et cetera, et cetera. So, and I love that we reached out to all sorts of different types of folks as part of this. I don't know if we mentioned that, but we talked to state lobbyists, we talked to campaign consultants, we talked to political attorneys, we talked to political treasurers, we talked to schedulers who have a lot to say about the FPPC and the Form 700 and all sorts of things. We talked to ethics councils, we talked to good government groups, we talked to folks at Common Cause. So we, while this is certainly not comprehensive, we did reach out to basically all the different groups that we interact with. So I'm glad we were able to do this, and great job. Thank you. Any other comments or commissioners? Excellent. Any public comment? Don't be nervous. Okay, perfect. Well, thank you, Ms. Yang. Thank you again. And let's move to our last item, and that is going to be item number 12, commissioner comments and proposed future agenda items. Do any commissioners have proposed future agenda items? Do we have any public comment? Okay, I'm hearing and seeing none. I'm going to move to adjourn. Do I have a second? Second. Ms. Vo?
Commissioner Brandt,
I stayed back.
I make the most motion.
No, step closer.
What?
oh, Commissioner Brandt,
Well, I guess I'll support it. Yes. Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Chair Silver.
Aye, thank you,
Meeting
everyone.
adjourned.
Thank you.
I hate to even run, but I got a point.
Now get out of here.